All right, good morning, everyone. We'd like to call to order the Judiciary Committee public hearing for April 2nd, 2026. Before us this morning, we have a class of 14 nominees to be judges of the Superior Court. Let me just review sort of our process quickly. We will call the nominees up individually. I'll ask you to just remain standing when you come up so I can administer the oath to you. Then make yourselves comfortable, make sure the microphone is on, and you can make a short opening statement for us, and then we will turn to the committee with questions. All right. Any remarks from my co-chair? Seeing none, we will start at the top of the list. And I will say this is in alphabetical order. No other reason that this person is first, but Campbell Barrett will go first. Attorney Barrett, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. Have a seat, and if you can figure out how to work the microphone, you can turn that on for us. Should be a button in front of you. Perfect.
Good morning. Thank you, Chairpersons Winfield and Staffstrom, Vice Chairs Flexer, Gadkar, Wilcox, and Fazzino, Ranking Members Kissel and Fishbein, and all the esteemed members of this committee. My name is Campbell Barrett. I want to express my sincere gratitude to Governor Lamont and his team for this opportunity. I am truly honored and humbled to be before you today. I am deeply grateful for my family. I am joined today by my wife, Susanna, and our 3 adult children. Their love and unwavering support has been instrumental in bringing me to this moment. I am the proud parent of a child with special needs. This is not something I ever anticipated, but is an experience that has shaped me both personally and professionally. I have learned patience, context, and perspective in ways I never could have imagined. I approach cases differently. I approach people differently. I have learned to define intelligence and courage in an entirely new way. By way of background, I have lived in Connecticut most of my life. I was raised and educated in Darien, lived in Hartford for many years, and for the past 20 years, my wife and I have called Durham home. I attended Trinity College here in Hartford and went to law school at American University in Washington, D.C. I have been in private practice throughout my career. I began at a small litigation firm on Oak Street, just a block and a half from here. I later joined Pullman and Comley, where I currently co-chair the family law and appellate practice groups. I am deeply appreciative of the mentors, colleagues, and friends I've made in both settings. To put it simply, I have been a divorce lawyer for 30 years. Early in my career, I handled a variety of civil and criminal matters, including multiple jury trials, but family law has always been the heart of my practice. Over time, I have developed a statewide presence, and I've tried many matrimonial cases in courthouses across Connecticut. Throughout my career, I've represented real people from all walks of life, individuals facing one of the most challenging and emotionally difficult transitions imaginable. These cases are never easy. They often carry a difficult emotional weight that can cloud the judgment of even the most rational person. Learning to navigate this is a daily challenge that I take very seriously. I've also dedicated myself to the academic side of law. I've argued multiple appeals before the Connecticut Supreme and Appellate Courts, including many cases of first impression that now guide family court judges in their decision-making process. Additionally, I've had the privilege of lecturing in Connecticut and nationally at scores of seminars on family law topics. I have written extensively on family law, including multiple articles and multiple book chapters. At its core, though, my work has always been about helping people, using the law to guide clients through a complex and deeply personal process. Over the past 30 years, I have had the honor of representing clients from all backgrounds, from captains of industry and professional athletes to those who are unemployed or just working hard to make ends meet. I've come to understand that the doors of justice must be open to everyone, and that no case is ever more important than another. Over the years, I've witnessed firsthand the profound impact that thoughtful judging can have on litigants and their families. I have seen judges who arrive early, stay late, and work through lunch, all with the goal of moving cases toward resolution. The best judges approach each case with respect, urgency, and a sense of purpose, regardless of the finances at stake. These are the judges I aspire to emulate if I am fortunate enough to be confirmed. I am truly honored to be here before you today, and I welcome any questions that you may have.
Thank you. Questions from the committee. Start with Representative Fishbein.
Thank you, Mr. Chairman. I'll start with a bit of a rant. This process is serious to me. I can't think of any other industry where outsiders employ employees upon a third party. Essentially, that's what we have here. We have the executive branch, the judicial branch, and the legislative branch. Executive branch is selecting individuals. Legislature is dealing with those individuals and then forcing them upon the judicial branch, who really has no stake in the process. The process here today, in my opinion, is a bit rushed. I didn't get the backup for the individuals until the entirety of the backup until yesterday. I was on trial yesterday in a case. It's probably going to go to the Supreme Court again, and therefore left with reviewing up until 3 o'clock this morning the backup. In my opinion, that is not justice to the process where we're forcing employees upon a branch of the government. That being said, I'll go on. Good morning, Campbell.
Good morning.
Nice to see you. I've known you for many years. I will admit that many times when I see you in a courtroom, I hang out to hear what you have to say. In fact, I did that in New Haven Court about 6 months ago. There was an interesting discovery dispute you were having, and I very much appreciated your argument and since adopted some of the points that you brought up to the court that day. I guess it's a way of dealing with the influx of pro se litigants in our courts is to take the most learned attorneys that we have practicing and put them on the bench. We saw that with Judge Dembo, who certainly has shown to be a beacon of justice and equity, and I see the same in your future. So, I hope that they give you family because you certainly have the background. Unfortunately or fortunately, you have a child with special needs, which I have a lot of experience in that area, and I understand that opens up the doors to things we don't necessarily think about as people without special needs. And that's something that we need more on the bench also. So I really have, your backup is excellent. I really have no questions for you. I just wholeheartedly welcome you and congratulate you on your nomination.
Thank you very much.
Thank you, Mr. Chairman.
Senator Gadkar-Wilcox.
Thank you so much, Mr. Barrett. It was a pleasure to hear your opening statement. And, what strikes me is your passion. Thanks also for sharing a personal narrative, and that you mentioned the sense of purpose. And clearly you're driven by a sense of purpose, which I very much appreciate, and your passion for the law. I just wanted to ask I appreciate seeing some of your pro bono work. If you can just say a little bit about, I'm guessing that it's that sense of purpose that drove you to take on some of those matters. If you can talk about that a little bit, I just wanted to know more.
I think we as lawyers all have a duty to give back to the system, and I've tried to do that in a number of ways. As I said in my opening statement, I co-chair the appellate practice group at Pullman and Comley. I have written a number of amicus curiae briefs for not-for-profit organizations in an attempt to help advance the law. I've also worked with multiple lawyers at Pullman and Comley, overseeing them as they represent folks in a pro bono sense. So I certainly appreciate the need for pro bono work and the duty that we all have to do it.
I very much appreciate you saying that, being committed to public interest law, and appreciate your submission, and good luck. Thank you.
Representative Oswald.
Thank you, Mr. Chair, and good morning, Attorney Barrett. Welcome. One of the great things about your application is that no matter how much time we have to review the submissions that we receive, I can open up your application and I can see before us a number of cases that we as family law practitioners rely upon every single day. You have a storied career in creating and crafting the law that exists today. So I'm ecstatic to see an application like yours before us. Anybody who has followed these proceedings before knows that I am passionate about putting experienced family law practitioners on the bench. So I'm grateful to have your application here today. And one of the things that I've started asking even seasoned judges is, one of the things that you will bring to the table as an experienced family law practitioner is the experience of what it looks like when a case is going south as an actual practitioner. And one of the things we hear a lot from constituents and folks who come to the public hearings is the abusive process that they feel sometimes with perhaps people who are gaming the system, who are acting in ways to use the rules of discovery or other procedural rules to gain a litigious advantage that outweighs the merits of the case. So I'm wondering if you can share with us given the perspective that you've done countless of these cases, what can you bring to the bench and perhaps share with your colleagues about how to spot those issues and how you might handle those cases as you see them happening to help try to curb some of those abuses of process to make the experience fairer and more equitable before the people who come before you so they can get to the point when they can have a decision on the merits, not on the procedure, preventing them from seeing the process through. Thank you.
So I can only give an answer from the perspective of a lawyer. I have a lot to learn before I can give any different perspective than that. But I think when you're talking about abusive process in divorce cases, delay is, in my view, the biggest problem. For whatever reason, the courts have some bit of a backlog and that it takes time to get into court. But I think ultimately getting into court, having issues heard is critical in eliminating the problems that you're identifying. And not to pander, Representative Osborne, but the amendments to 46B 83, I think go a long way in remedying that. The ability to get into court within 60 days, if necessary, really helps litigants and really helps avoid the game playing that you're referencing.
Well, thank you for that observation. And again, I'm just delighted to have your application before us today. Good luck. Thank you, Mr. Chair, through you.
Representative Pavlik-Tomato.
Thank you, Mr. Chair. I just want to say I do serve with Attorney Campbell Barrett on the Child Support Guidelines Committee, and I have to say it is a pleasure to serve with him on that committee. He has been extremely helpful, just a lot of input from various perspectives, actually, from the different types of cases that he's handled. And I do always make sure that I, just like Representative Fishbein, I do look forward to what he has to contribute, and I do look forward to his future service on the bench. So thank you.
Senator Winfield.
Thank you, Mr. Chair. Good morning. I'm glad to hear so many of my colleagues with a favorable opinion. Congratulations on your nomination. Representative O'Day and I play kind of a tandem usually on this committee when it comes to judges. You may know that he asked the question about robitis, and then I ask a follow-up question. Because that question is usually answered with some form of, this is what I normally do, this is my normal temperament. My question is more of, when things get rough, what is your system of accountability to make sure that you can actually maintain that temperament? So if you could speak to me about what your system is, I would appreciate that.
Thank you, Senator Winfield. I am lucky. I have a very strong support group of mentors that I look to, and they are experienced judges, both retired and sitting judges. And I certainly look forward to leaning into that relationship as assuming that the next step is successful. But I think more importantly, I think that what I think is critical is to rely on the people that are immediate, to rely on the people that are with you. And I think I see great value in judges having a relationship with the team that they work with the clerk, with the court monitor, with the marshal, and having a trusting relationship and being able to look to those folks and say, hey, was I a bit heavy-handed there? Was I a bit imperious? And learning from that. And I think that starts with the judge. That starts with the judge creating a scenario where there is that trust, where the other folks are comfortable giving that type of feedback. And I do that in my private practice, and I would like to do that as I move forward.
Thank you.
Further questions or comments from the committee? Further questions or comments? If not, Campbell, just a couple quick questions. Representative Pavlik D'Amato brought up the Child Support Guideline Task Force. Does this mean I need to appoint a new designee? Since-
I think it might.
Okay. All right. If there's anybody listening who's interested, my clerk's over there. He's taking applications. No, in all seriousness, I think, as folks on this committee know, Campbell and I have been law partners for the last several years, many years. The entire time he's been at Pullman. There is very few finer lawyers I've had the privilege of working with than Campbell. His ability to dig into an issue, his ability to take and distill the law and the facts of a case and to present it, and also his leadership within the law firm setting, I think are all going to be extreme assets to the bench. And certainly the judicial branch's gain is Pullman and Cumley's loss. So Campbell, I wish you nothing but the best of success as you go
Thank you very
forward.
much.
All right, next will be Jeff Beckham. Raise your right hand. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Good morning, Chairman Staffstrom, Chairman Winfield, ranking members Representative Fishbein and Senator Kissel, Vice Chairman Senators Flexer, Gadkar, Wilcox, and Facino, and distinguished members of the Judiciary Committee. I'm grateful to Governor Lamont for this nomination. I thank General Counsel Braswell and her staff for their assistance. You have materials that describe my career to date, and I'm happy to elaborate on any of my experiences. In terms of my background, I am the proud son of a single mother who overcame many challenges to raise me and to give me the foundation for what has been a fortunate and privileged life and career. Today, I am mindful of the fact that I would not be sitting here if I had not had the love and support of my wife of almost 26 years, with whom I have raised our two sons, who are our pride and joy. As to my motivations for being here today, I believe that the health of our society depends on the willingness of people of goodwill to step up and take their turn maintaining the institutions of our precious system of self-government. This is especially true of those who possess knowledge or skills that can be of service to those institutions. The judicial role has long been an aspiration for me. I have a unique set of experiences and have developed knowledge and skills that I believe would allow me to add value as a judge. In my career, I have been recruited several times for new jobs that entailed getting up to speed quickly on complex topics that I had little or no familiarity with prior to being recruited. At every stage, I was fortunate to have colleagues and mentors willing to help me. I've never been bashful about asking for help and advice, and I think that played a big role in helping me succeed in those jobs. I understand as a judge, I will have a mentor judge and an experienced clerk staff for support and assistance. I will not hesitate to lean on them until I am proficient in the matters coming before me. I've been remarkably fortunate to have worked as a drafter of laws in the legislative branch, a legal advisor to executive branch decision makers, and a decision maker myself as an executive branch agency head. As an agency head, I have had to process complex and sometimes conflicting information concerning policy and budget options, often having to make a prompt decision. Refereeing a vigorous debate and then deciding on a defensible outcome has been a significant part of my job. Our courts are the place we go to get justice when we cannot or should not get it on through our own efforts. Since statutory law does not predict every fact pattern that may occur and judicial case law is not always directly on point, we need the courts to interpret and apply the law in each case. Many times the judge provides a key human element in establishing what is fair and equitable in the case, consistent with the law. If confirmed to the judicial role, I understand that I will have to resolve cases that impact people going about their everyday lives. The decisions made by judges have tangible consequences for real people. If you see fit to confirm me to this role, I will consider it my humble obligation to judge with care and to do justice consistent with the law. Thank you for your attention.
Senator Winfield.
Thank you, Mr. Chair. Good morning. I'm just going to get right into the question that's in front of everybody. No need to play around. This committee is often engaged in asking folks with little or no experience in the courtroom about what makes them someone that we should endeavor to continue forward. And you suggest, and let me just say that your public service is acknowledged and I think important. You suggest that you have the capacity demonstrated by your history of getting in and figuring it out pretty quickly. That's a good thing. But the things that you've figured out, the decisions you've made have been, to a degree, if they weren't good, moderated by the fact that there were other decision makers in ways that they won't be in the courtroom. So can you talk to us about the experience, the direct experience that you don't have in your underlying documents to the committee, and that gap and why we should continue you forward?
Well, I think your question assumes that you know that I don't have a lot of courtroom experience, haven't tried cases, have not been a practitioner in private practice, not to any extent and not recently. And I'm fully conscious of the fact that I have a lot of homework to do. I have a lot of, there'll be a learning curve for me, and I'm committed to doing that work. I understand I'll be given a mentor judge, as well as there's an experienced clerk staff in all the courthouses around the state that I expect to lean on and develop a relationship with them such that I can lean on them for their knowledge and experience. I have a lot of work to do, and I've demonstrated an ability to do that. It's the skill set that I think commends me, not the direct substantive experience.
I appreciate that answer. I will push on you a little bit because that answer feels a lot like what was in your underlying statement. So I'm going to ask you, you may not have something more than that, but I'm going to ask you if you have anything additional to add. If you don't, I just ask you to describe to me what you think your judicial philosophy would be.
I think that it's the obligation to try and do justice, to try and do what's right in each case as it comes along. In some cases, you'll have discretion. In some cases, you won't. The case law will be pretty clear, or the statute's pretty clear. But in those cases where you have an opportunity to do the right thing, to make sure that you've given the parties a fair shake, that they've had their day in court, and that they felt like whatever results was a fair process where the judge was neutral and impartial and did not have a stake in the matter. But that when we can do justice and do the right thing, that'd be my guiding goal.
And I usually wait towards the end for this question, but since I'm talking to you now, your system of accountability that you have in place, we don't know anything about your temperament as a judge, understood, but what is your system of accountability?
Something I've internalized in 20 plus years as a manager in the executive branch and as an agency head is that you are always going to be subject to accountability. You have to start with the proposition that whatever you're doing, you need the authority to do it. You have to be on clear authority, solid ground to take whatever action you're taking. And in the course of doing so, you have to be professional about it. There are multiple agencies and offices that are looking over your shoulder when you're a public official in the executive branch. We have a collective bargaining system where our employees can take grievances against their coworkers or their managers. There's our Personnel Act and its regulations, which provide grievance rights. If you abuse someone or are negative towards someone, they have an outlet for that. There's the Commission on Human Rights and Opportunities that may bring actions against agencies or individuals if you deprive someone in a protected class of their rights. The General Assembly looks over the shoulder of the executive branch. I've had to account to the Appropriates and Finance Committees for the last 4 years on any number of issues for which I had to be on solid ground as to what we did and why. So both in the substance of what you do and in how you go about it, there are so many opportunities, in my experience, for you to be called to account that you simply have to internalize the idea that you don't have carte blanche to just do whatever you feel like doing. You've got to ground everything in what you're doing in authority and the ability to defend it later.
Appreciate that. I'll reframe the question because those are what you described as mostly external accountability. I'm talking about your own system. What have you put in place to hold yourself accountable, to control yourself in situations where things are not normal, not the way from day to day they would operate?
Well, I think you have to rely on the people you work with for one thing. One thing I've been told, I have the benefit of knowing a few judges who've been very generous in reaching out to me and talking to me about the experience. And I'm advised that you are well supported in the branch. There's an administration that supports you. There are clerks there. You have your fellow judges nearby. And in the beginning, you have a mentor judge. I think it's important that you, as you're going about your business, you have to be aware, you have to have self-awareness. And you can talk to other people about that, talk about how things went that day, or how they might handle things that are coming up. So being prepared, I think, and just having an awareness, a self-awareness of how you're going to be perceived, especially by the parties. The parties need to know that you don't have a stake in this matter that they brought to you, and that you're not favoring one of them or the other. So that neutrality and partiality in the courtroom is going to be critical.
Appreciate that. I will just say this by way of comment. Almost every person, whether they were a nominee or a sitting judge who ran into an issue, at least in front of this committee, believed that they had the ability to do what they needed to do by being self-aware. Turned out not to be correct. I would hope that as you move forward, you come up with an answer that is not about your self-awareness, but more of a type of system to ensure that when self-awareness does not do well by you, that you're able to do what we need of a judge in our system. Thank you, Mr. Chair.
Representative Fishbein.
Thank you, Mr. Chairman. I do appreciate the comments of the chair. I harbor the same general concerns. Sir, when did you go through judicial selection?
2010.
So almost 2 decades ago. In your, we did pass a law last year that knocked people off the list after, well, originally the language knocked people off the list after 8 years. Then it went to 10 years, and then it just went away. Because as I've already said, this process is serious. You make people go through judicial selection, you get on a list, and I'm not the same person I was 17 years ago. I take this process seriously. Sir, in the background, your backup, you said criminal law presents an interesting challenge. What is your knowledge about criminal law in our courts?
Minimal. Back in the day, I was a temporary assistant clerk a long time ago, admittedly. I do recall some trials. I do recall marking evidence and recording orders of the court, and those were fascinating. Watching the lawyers elicit from the witnesses the evidence. It's that sort of thing. I remember discussing some of those matters with the judge in chambers, or we occasionally had the ability to go to lunch with judges, and it was fascinating to hear their perspective. It was a while ago, but I remember that was an intriguing experience. And
I was a
enjoyed
TAC too, over 20 years ago. But my concern is that every single case that comes before a judge in our courts impacts someone's life. There is no, I'll get my training wheels out, I'll figure it out in 6 months, because that very first case is impacting someone's life. And let me just explain, that the criminal, whatever. In a family case, a pendenti liti, a temporary order on custody or visitation, which is a very important thing. And people think, well, it's temporary. It's it's an unappealable event. You impact children and parents, but I usually think about the kids first, by making those orders that are unreviewable. In my opinion, we can't just throw people on the bench and say, figure it out. Maybe you'll impact somebody's life, maybe you won't. I'm not willing to take that risk. Sir, you also talk about administrative appeals in your backup. What's your knowledge as to administrative appeals in our courts?
Just that folks who are aggrieved by actions of state agencies can appeal those after they've exhausted their administrative remedies to go to the Superior Court. And obviously, I have some knowledge of how those decisions get made from the executive branch perspective, and the fact that they have in-house counsel who will have given them advice about their authority. And so I have a passing familiarity with how that happens from the executive branch side, but I obviously haven't handled those cases in court.
And are you aware what particular courts handle administrative appeals in our court system?
I believe there's a special that's an assignment for folks with knowledge and experience in that area. I know there's a tax court that's a specialized section, administrative appeals.
Now, the backup also indicates that you were licensed to practice law in California in 2000, but I don't see a California connection. Can you just explain that?
My wife's from California, and there was a time when we thought we might relocate out there. So I tried to make sure I had the ability to go out there if we wanted to, but we did not. We wound up staying in Connecticut, which we're both big fans of, and we've been happy and proud to raise our family here.
And you've maintained that license since 2000?
My status is inactive. I pay a fee every year. I stay on their books, but I've not practiced, and I don't otherwise have a connection to legal matters.
When somebody goes through judicial selection, one of the things they're looking at is demeanor, respect for other individuals, and obviously you haven't been vetted through that process in 17 years. Can you talk to some examples of demeanor, respect for other individuals that would in some way, shape, or form evidence that before us here today?
Well, as an agency head and a colleague in executive agencies, I've had to interact with a lot of people. I've had to interact with the General Assembly quite a bit. I was an undersecretary for legislative affairs and was a liaison for agencies. I worked with many people in the General Assembly and the staffs of the General Assembly. So I've certainly had the experience of working with lots of people. I have a reputation among them. I have a reputation with the legislative leaders with whom I've worked, with the chairs and ranking members of the Appropriations and Finance Committee. So there's a reputation out there that I'm content to live with. I believe, to the best of my knowledge and belief, I have a strong and positive reputation with the people with whom I've worked.
Can you tell us the most difficult ethics situation that you've run into as a lawyer and how you dealt with it?
Well, I'm trying to think of a specific example, but I've always sought counsel. If we had counsel, I wasn't relying on my own research. If it was something of that nature, I'd want to run it by someone else and would have done so. I'm not sure I have a specific example in mind of a particularly difficult ethical matter. It was part of my job when I was at several of the agencies was to be involved in procurement matters. Those have to be done in a competitive selection process where there can't be favoritism or communications that with one of the parties who may be bidding. So I had to be quite aware of the ethics situation there. I was the ethics liaison for several years at some of the agencies I worked for. I actually had to counsel and train people within the agency on ethics matters.
Yeah, I just want to give you another, I'm really wrestling with is it a benefit to the citizens of the state of Connecticut to approve of your nomination, or is it of benefit to you as an individual? And I'm balancing the two. Can you just unpack that? Why should I put you as no experience in our courts? Why should I approve of your nomination for the betterment of our state as opposed to the betterment of Jeffrey Beckham?
I bring a set of experiences and skills developed over almost 36 years of service to the state in the service of it in both the legislative and executive branches. and have on multiple occasions stepped up and handled difficult matters that have been I've been asked to do, including becoming secretary on fairly short notice. So I have an array of skills and experiences, and I'm committed to deploying those and helping the branch do its work. I know that the job of the branch is to handle the matters brought to it, but to also advance justice, to do justice wherever you can. And I'm committed to that principle.
I appreciate the answer. I just, I hear all the time, what am I going to do with this one? When we thrust someone on the judicial branch, what am I going to do with this one? I mean, but anyway, I defer. Thank you, Mr. Chairman.
Further questions or comments for Representative Gadkar Wilcox?
Thank you, Mr. Beckham. I just had a question for you. Just in anticipation of this and your role, how much time have you spent in the courtroom, maybe like since you left OPM in the last couple of years?
Well, I haven't been spending time in the courtroom since I left OPM. I'm still at OPM in advisory capacity. When I started out in my career 36 years ago, I was a temporary assistant clerk in the court. So I worked with judges on matters in that time frame. I was a junior associate for about 8 months in a private firm, and I argued some short calendar motions, as I recall, and worked on pleadings. I did a lot of title searches and conveyancing work in those 8 months. I answered an ad in the Hartford Courant for the Legislative Commissioner's Office in 1990 and began a career in public service. That was my interest. My resume is in your packet. From the legislature, I went to the executive branch, served in a variety of capacities there. Eventually was in position at OPM that the governor turned to me to lead that agency when that position became vacant.
No, and thank you. I appreciate that. I appreciate your service. I just been in the last couple of years to shadow a judge, to watch how many hours have you spent like in the courtroom, sort of trying to understand the process that you will now be leading in the
Sure. No, I've had contact with the branch. I've worked with the chief court administrator on issues involving the branch and its policies and its budget. And I've visited some courtrooms when I was at the former Department of Public Works and DAS. We built a new courthouse in Torrington, so I was out there as it was being constructed. But I haven't observed or been in the courtroom in the last several years.
So I'm just curious. I mean, I know you said it a little bit in your opening statement. That this is about your serving, and I appreciate that because it's important to serve the public, but there are a lot of ways to serve. So, why this role? Why is this important to you to serve in this capacity, given the gap and given the other things you've been doing, and that you continue to serve in other kind of public capacities?
It's been an aspiration of mine for some time. As I say, I went through the process in 2010 to get on the list. I've had conversations over the years about getting to this, able to do this role and have this experience. More recently, I hadn't been thinking about it, but I was approached about did I still have this interest? And I did. So I'm grateful for the nomination.
Thank you.
Representative Fazzino.
Thank you, Mr. Chair. Attorney Beckham, good to see you, albeit around Representative Osborne's head. Thanks for being with us this morning. I thought you said something pretty interesting in your opening statement about having a career in public service that depends on making decisions and justifying them. Obviously, the method of justification is very different when you're a judge of the Superior Court versus the Secretary of OPM. And the methods of justifications, the reasons behind them can vary significantly, right? I mean, I see it. Many of us who practice law and who exist in this building see it where, if you make decisions here, you have to, explain them to a room of people, but oftentimes you are the be all end all for that decision-making process. When you're a judge of the Superior Court, obviously, you have a written decision that's a matter of public record that will serve as important precedent for future cases and can be subject to appellate review as well. I just wanted to maybe give you an opportunity to expound a little bit more on how you're preparing yourself for this shift, right? And how you justify the decisions you're making in a public capacity and how you've sort of internalized the effect of those decisions for years to come?
Well, when parties bring matters to court, they obviously have a strong interest and it may be their worst day of their life when they come to court. You have to assess the facts and get a read on what's going on in that matter. Hopefully, there may be other people who can help you in the family context. I'm aware that there may be other people, experts, third parties who will give opinions as well. But you try to weigh all that, and then you have to apply the law to those facts and do your best. And it has to stand up. It has to be defensible. You can be appealed. The news media may take an interest in what you're doing. You have a judicial branch administration that will take an interest in how you're doing your work. So whatever I wind up doing, I will have to be able to justify it and explain it in a way that the parties understand. The public won't respect the results if you can't explain what you did and why it's fair and equitable in that case. And that's something I would be very mindful of. In the work that I've done to date, whether it's me or the staff I lead, I've always been aware we need to justify what we're doing in terms of what's our authority and will we get at the result that we think is the right one in this case. So that's the approach I would take. And certainly you're quite right explaining it to the parties or putting it on the record in a way that it will be upheld and be understood by the parties to have been the result of a fair and equitable process will be key.
Representative Callahan.
Thank you, Mr. Chair, and Mr. Beckham, thank you for being here today. I apologize for not being in front of you in person, but I had a conflict. I've listened intently to the questioning of your nomination, and I just came up with a couple additional questions that I need to know, having been a judicial branch employee for 30 years. There are obviously a lot of attorneys that have spent a lot of time in the courtroom that would love to be in front of us today with a shot at being a judge, who've spent a lot of time arguing cases, a lot of time in our superior court. Why should we approve a position for you ahead of all of them?
Well, I'm offering my services. I'm interested in doing the work. I believe I would add value as a judge for the reasons I've stated. I'm committed to doing the best job that I can do as a judge and being of help to the branch in moving its caseload, as well as making sure that the folks who come to court get their fair shake and get their day in court. And it would be my commitment to do that job with as much humility as I could and to try to bring justice in the cases where I was able to do so.
Well, thank you for that. I'm still struggling to come to terms with the fact that this is a very old approval by the Judicial Selection Committee. You haven't spent any time in court, and the judicial branch, when you're in a courtroom, you're dealing with, as others have asked you, you're dealing with marshals, with clerks, with defendants, with private attorneys, with public defenders, probation, family. How do you see yourself managing that? Because what you do can change the temperature of that courthouse. And how do you see yourself managing that staff while you're on the bench?
I'll bring to that role the same dedication I brought to leading all the staffs that I've led in the executive branch. To work as a team, to get the best result, you have to foster an environment where people feel like they're valued and that they're heard, and that they make a contribution. You have to respect everyone else's contribution in that courthouse, and to rely on them. And I expect to rely on them heavily to do this job well.
Thank you. And would that be the opinion of the people you work with now?
I believe so.
Thank you for the answers, and thank you, Mr. Chair.
Further questions? Mr. Beckham, let me just first start by saying and this is not a knock on the branch whatsoever. And if anything, maybe it's a reflection on us as a legislature. But I think from some of the comments I've heard, I think you may be overly optimistic about the level of support and resources available to the branch. I mean, I think we as a committee hear all the time about how under-resourced the branch is, how we continue to put more judges on the bench, but we don't have the requisite number of marshals. We don't have enough clerks. We don't have enough support staff. I mean, and I think that has been a concern. I know normally when you're in this room, maybe there's a different committee sitting up here instead of this one, but I think this committee, I think we hear all the time about the lack of resources. So I just don't want to sort of leave the impression out there that that the branch is getting this support that it deserves and it needs, because certainly from where I sit as head of this committee and as somebody who practices in our court on a day-to-day basis, I don't think that's accurate. Let me ask, or maybe let me let you try to answer the question that I think everybody's been trying to ask, maybe a different way. So you talked about how this is sort of a lifelong goal of yours, and that you've been on the list for a number of years, a decade and a half, and how you're willing to do the homework in order to learn the job. I guess the question I have is, what homework have you done leading up to today to prepare you for the job?
Well, I've been trying to familiarize myself with the practice book and its contents, the rules of evidence, the Code of Judicial Conduct. Judicial branch has recommended some readings regarding the transition to the bench, doing all that reading. I've had the benefit of some judges who I know who've reached out to me and given generously of their time, both on the phone and in person, to talk about the role and talk about what's involved. I've done some reading of a judicial memoir of Judge Satter, who passed away about 15 years ago. So that sort of thing.
What about CLE programs? I mean, as a lawyer in the state, what sort of continuing legal education classes have you taken? What sort of, writings have you done? I noticed in the background you hadn't done any pro bono work per se, but what sort of activities have you undertaken over the last several years?
Well, I have fulfilled the CLE requirements with online courses since that came into effect a few years ago. Have not had occasion in the last few years to attend legal seminars. When I was general counsel in a couple of agencies, there would be seminars or conferences that I would attend on topics like labor law, procurement law, that sort of thing. It's been a few years, but that's been the extent of it. No writings beyond the ones that I offered a few from a number of years ago in the packet.
All right, and I don't know that we ever quite got an answer to Senator Gadkar-Wilcox's question, which I think was, when was the last time you sat in a courtroom when court was in session?
That would be 1990. The fall of 1990 would have been the last time. As a junior associate, it might have been a short calendar. It might have been some pleading, that sort of thing.
All right, thank you. Anything further from the committee? If not, congrats on your nomination. Next will be Theodore Doolittle. You'd raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? Great. You can have a seat whenever you're ready.
Chairman Winfield and Staffstrom, Vice Chairs Flexer, Gadkar, Wilcox, and Fazzino, ranking members Kissel and Fishbein, and honored members of the Judiciary Committee. It's my honor and privilege to come before you today and humbly request your support for my nomination to Superior Court. I would like to thank Governor Lamont, Council Braswell, and the rest of the governor's team for selecting me for nomination among scores of other highly qualified potential appointees. I currently live in West Hartford with my wife, Catherine Ingustian, who is here. She's a staff attorney with the State Department of Transportation. We have 3 kids, 2 adult daughters, and our youngest, a son who is in his first year at UConn. Go Huskies. My wife and kids are the most important things in my life, and I look up to each of them. I wasn't born in Connecticut, but I got here as fast as I could, which is in my case, was 9 years old. I grew up with my mom, dad, and 4 brothers across the street from the famous red-covered bridge over the Housatonic River in West Cornwall. You could hear the rapids from the porch on our house. As a boy and young man, I spent hours on the banks of the Housatonic and the streams and lakes of the northwest corner, fishing, reading, and dreaming of a life in public service. I went away for college and returned to Connecticut to attend the University of Connecticut School of Law, where I was editor-in-chief of the Journal of International Law. After law school, I clerked for federal trial and appellate judges, then served as a prosecutor and appellate attorney with the Department of Justice in Washington, D.C. I ultimately returned to Connecticut to the Office of the Attorney General, where I handled Medicaid fraud cases and other major fraud and whistleblower matters. In 2011, I was appointed to be a top anti-fraud official at the U.S. Department of Health and Human Services in D.C., so my family relocated temporarily. We returned home in 2016, and Governor Malloy nominated me, and this body confirmed me to be the head of the State Office of the Healthcare Advocate, which provides free legal representation to residents of Connecticut fighting health insurance claim denials or other problems with their health insurance coverage. I've wanted to be a judge since I was a boy. So as much as I loved fighting for families, your constituents, as the healthcare advocate, after much reflection in 2023, I left that office to accept appointment as a U.S. immigration judge here in Hartford and returned to my first love of the courtroom. I loved being a judge. While immigration judge is in many ways a supremely difficult job, it was a great honor and high privilege. I gave it all I had. My goal was always for the attorneys from both sides and the families before me to understand why I made a ruling, even if they did not agree with the result. I started as an immigration judge in September 2023 with 38 other new judges around the country. In September of 2025, shortly before the end of our 2-year probationary period, most of the judges in my class were terminated, including me. We received a brief form letter giving no reason for the terminations, other than that the administration was exercising its authority under Article 2 of the U.S. Constitution to remove federal employees. Most of us, I believe, were good attorneys and good judges. In my case, it seems likely that the termination was not performance-related, as several weeks previously I had received probably the single best performance evaluation of my career from a supervisory judge recommending that I be retained after the upcoming end of the probationary period. I feel that my skills and temperament make me well-suited to be a judge. I'm honored to be here to humbly request that you consider approving my nomination to continue my judicial career as a Superior Court judge. I'm happy to answer any questions you may have.
Thank you. Representative Fishman.
Thank you, Mr. Chairman. Morning, sir. I know you did try to talk to me. You were in the elevator the other day, but I just by rule do not, this, as far as I'm concerned, is a public process. I don't meet with people behind closed doors. But I do appreciate, the attempt.
I think it's a great policy.
Well, thank you. I will tell you, when I first took a cursory look at your backup, I had the thought, what are we going to do with this one? And I was wrong, and we'll get to that. Because one of the things that jumped out at me is you went through judicial selection in December of 2007, almost 20 years ago. But then when I dove deeper, this seems to be a smooth transition. You write very well. I was very impressed by your the writing samples, the backup. The one question, when you got terminated, maybe a very draconian word, but in August of 2025,
September.
What did you decide? What was your path at that point? You didn't have the nomination. You're over 60 years old. Were you retiring? What were you going to do?
Well, as I mentioned, my son is a freshman at UConn, so I wasn't going to be retiring. But I immediately, of course, started looking for what my options might be. Including trying to pursue this opportunity, which I knew there's very few folks that get nominated. It only happens once a year. So I started looking for a number of jobs. Representative Fishbein, I was trying to focus on legal jobs. I was in talks actually until recently with a local immigration firm. I also was a finalist for the executive director of the Connecticut Legal Services. So I was determined to try to stay in the law, certainly in public service, broadly, if I could. And this opportunity came up, a number of weeks ago.
No, I appreciate that. Because when I looked up your juris number on the judicial website, I saw there wasn't an address. Yeah, I have it here. It says, it says address not available. Now, maybe.
I think there's a box you can check, when you register every year to whether your address should be available to the public or not.
Yeah, so maybe because at the time of your last registration, you were serving as a judge.
So I probably had the 450 Main Street Federal Courthouse address.
Yeah, well, it says address not available, but under federal law, I believe the addresses are of a level of protection. So that very well could be why, but it just prompted that. Once again, I just think it's a smooth transition, and congratulations on your nomination. Thank you, Mr. Chairman.
Thank you, sir.
Thank you, Representative Senator Gadkar Wilcox.
Thank you so much. Thank you for being here and for your testimony and for your service as an immigration judge. If I can ask you about that as a litigator, I did conduct an asylum trial. This was years ago in like 2006, I think it may have been. But
in Hartford?
In New York City, in New York, yeah. So one of my questions, one of the things that doesn't come up often when we have discussions on immigration is what can we do? What does our actual immigration system look like now, and where is reform appropriate? And I would love to hear your insights, because one of the things that struck me from that time, and again, things may have changed in the immigration court since that time as well, but is the level of discretion that judges have, and the standard it's very different than the standard in other courts, and in ways that's problematic, perhaps. And it's very minimal in some ways. In other ways, at the time, you had a number of law firms, like where I was, where you had pro bono services for certain individuals, which was raising the standard in terms of the burden of proof for evidence that other individuals who are largely pro se, would not be able to meet. And so there were just a number of issues I remember that came up around that time. And I would just love to hear your insights on, what could we do better in immigration court today when it comes to standards, when it comes to burden of proof, when it comes to just the adjudication of the entire process. So any insights you want to share on that, I appreciate.
Yeah. So let me start by saying that one of the main things that has filtered into the consciousness of the public is the backlog in immigration courts, which is dramatic. And to me, that's really on us as a society and a community. It's simply a matter of resources. I think there's spots for 700 immigration judges. There's no reason we shouldn't have 2,000 immigration judges. And that would, of course, make there be more trial dates, right? And so the cases could move faster. So it's really on us as a committee. It goes back to Representative Staffstrom's comments about the resources under the judges in the judicial branch. We should do more. I was dismayed, for instance, when there was a recent restructuring, let's call it, that where the administration announced they're going to have 10,000 new immigration agents, and they added 100 judges. To me, I was like, why not add 5,000 new officers and add 1,500 new judges if you want to really get due process to get it down quickly. So I think a lot of the problems that people see in immigration court could be alleviated if it was properly resourced, which we haven't been willing to do. Obviously, there's also, you referenced some of the legal really complexities. I started my career as a tax in the tax division in the United States Department of Justice, so I know complex statutory frameworks and what that looks like and feels like. Immigration law is as complicated as tax law. It's almost unbelievable. That's an inappropriate arena to throw a pro se litigant into. So along with the resources, I think, again, in terms of getting the backlog down and making sure there's due process, we can simplify the requirements that you're talking about, but also we should provide attorneys some type of legal help, because then the system can move much faster. Many's the time I had to have pro se litigants, that's litigants that don't have an attorney, in front of me 2 or 3 times as I explain the process to them. If it's a skilled attorney, you don't even need, let alone 3 hearings, you don't need any hearings. You do it on the papers, you get it ready, and then you go to trial. And the only time the attorney and their client might have to come into court is just that one time for the trial, because everything else is done on the papers. You can't do that with a pro se. So those are some of my thoughts.
I very much appreciate everything you just said. And, you know, when we talk about what's wrong in a system or what needs to be done, we're not focusing on what can be right or what can be better. How can we correct the things that are wrong? And usually that is about investment. So, so putting those resources in, absolutely agree. And thank you for talking about the complexities. And I noticed that too. And the one thing I struggled with as a litigator, particularly being in a large law firm, doing the pro bono work for an asylum trial, was, you know, the ethics of changing that burden. Because now, if that's what you're seeing for a number of cases, you know, I know, and there was an article about it in the New York Times, actually, at the time when I was a litigator, that the standard is changing because the expectation now for the pro se litigants or the pro se petitioners is higher. Because as a law firm, as an associate at a law firm, I was able to take my time and use the resources available at the law firm to be able to gather evidence. And now that burden of proof or that standard of evidence was higher. So I struggle with that, because you want the pro se access, but when you have, you want the pro bono you want the access to sort of the law firm resources, but when you have so many pro se litigants, how do we balance our commitment then to the due process obligations that we have, especially when somebody is claiming asylum and you're really trying to understand whether or not there's a credible fear of persecution. That's our most fundamental legal mandate.
Yeah.
Yeah.
You know, in a criminal trial, the burden of proof is on the government. So the government has to prove guilt beyond a reasonable doubt. In asylum cases, it's entirely the opposite, with the exception of proving that the person is not a U.S. citizen. The government has that burden. That's the only burden the government has. Other than that, it's purely on the litigant. And I just question whether if we have a system where we have somebody from a foreign country, maybe an elementary school or even less education, and pro se, how can that be due process unless they are able to get some type of counsel?
Assistance. Yes. Well, thank you. I'm sorry that you're not there in that context, but I'm glad that we have the opportunity for you to serve the state of Connecticut. Thank you very much.
Thank you, Senator. Representative Osborne.
Thank you, Mr. Chair. And good morning. I think it's still morning, and thank you so much for being here today. As somebody who is very interested in how our state courts function, I'd like to sort of turn my attention to the state court functioning that I'm in, which is family law. And first of all, I'm delighted to see all the litigation experience you've had, all the courtroom experience you've had. That really makes me happy as a trial attorney to see trial attorneys becoming judges for us. And as healthcare advocate, I know that the people who reach out to the healthcare advocate's office are in a frantic place. By the time they get to you, they are desperate. They are in, a fight for their lives often, and fighting with health insurance companies and trying to get treatment and coverage that they need. And that is often the case for litigants who come before family court judges. It feels to them like an existential threat to their existence, and they can appear in a very frantic, very disorganized way. And I'm confident that the experience you have had as a healthcare advocate will actually hold you in good stead if you get to an assignment in family court. Because I think that it takes not just a knowledge of how to try a case, not just the rules of evidence, not just the rules of hearsay, not just the practice book, but it takes an understanding of what the people before you are experiencing. And there are not a lot of people who have that kind of experience. So I just wanted to say thank you for applying to do this job. And thank you for the breadth of experience you bring. And thank you very much. Thank you, Mr. Chair.
If I could just make a comment. So immigration court's not family law by any stretch, but there's families in the courtroom all day long. And I know that, the families would come. Sometimes the parents would be anxious and the little kids would be a little bit going out of control. I several times come up around the bench. I try to reassure them. It's okay. I know where the electrical outlets are. I'll don't worry about the kid. It's important for the judge to try to set everybody at ease when there's that high stakes emotional situation.
Thank you, Representative Blumenthal.
Thank you, Mr. Chair, and thanks for being with us today, Judge Doolittle, and for your comments and answers to our questions. I don't really have a question for you. I just have kind of a comment, which is obviously you're eminently qualified for this role. You have much more experience than some of the best nominees we see. My comment is primarily focused on your time and your role at the Office of the Healthcare Advocate, because you know this, but I guess this is mostly for the public. It is such a vital role. And as Representative Osborne said, people are in a fight for their lives when they come to that office for assistance. And I just want to say personally, thank you for your work in that role. You changed the lives of my constituents. You worked with such diligence and skill. And I know you've probably heard thank yous from people, but people thanked me for putting them in touch with you and making them aware that there was someone in government who knew the law, who had such skill and stick to it with itness to get those kinds of results. And I just can't recommend you highly enough to anyone else who may have any questions about you. As far as I'm concerned, my only complaint about your nomination is that it didn't come to us sooner. So thank you for your service to the state, to my constituents, to all of the constituents of us who have had the good fortune to benefit from your work so far. You're somebody who has taken on tough jobs, done them extremely well. And I know this is one where you'll excel, and I hope to have the honor to appear before you.
I just really want to make a comment, make sure everybody understands. The Office of the Healthcare Advocate has a team of attorneys, paralegals, nurses, others who can represent anybody in this room who has a Connecticut connection. There's no income limit. You can be from the Hottoniest areas in Darien, or you can be from Willimantic. We are allowed to take all the cases. And if you have a claim denial or anything else, right when you are sick is the wrong time to have to deal with bureaucratic challenges. So pick up the phone, Google, go and find your free advocate, the Office of the Healthcare Advocate. I will say, Representative Blumenthal, that it was a agonizing decision for me to leave that job. I do regard that job as the best job in the executive branch this side of Attorney General. And I'm delighted that Kathleen Holt has taken a hold of that office and is really taking it to the next level.
Well, thank you for those comments and that public awareness and for your service to the state. Thank you, Mr. Chair.
Thank you, Representative Blumenthal. Senator Lesser.
Yes, I want to associate myself actually with the comments of my good friend, Representative Blumenthal, and just say, Ted, it's good to see you. Congratulations on the nomination. You know, like others on the committee, I had the opportunity to work with you extremely closely in your former role at the Office of Healthcare Advocate. And I also very familiar with your work at the U.S. Immigration Court. And so I'm hoping you will take your extraordinary skills to continue to serve the people of the state. I know you're committed to fairness, to the least among us, and you will bring your ethics and your hard work to the bench. And I'm just thrilled to see you nominated before us here today.
Thank you, sir.
Thank you, Senator. Further comment or question from members of the committee? Further comment or question? If not, Attorney Doolittle, I want to thank you for joining us today. Sorry we didn't get to meet up, but I'm not asking you the question I ask everybody. That should indicate how much I support your nomination. Because most people don't escape. Yes.
Thanks, everybody, for your time. I know I know it can be a long day, and I do appreciate it.
Thank you. Okay, next we have Patrick Fahey of South Glastonbury. Once you're settled, please raise your right hand. Okay, do you swear or affirm, as the case may be, that the information you will provide to this committee will be the truth, the whole truth, or nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide us with your opening statement.
Good morning, Chairs Winfield and Staffstrom, Vice Chairs Flexer, Gadkar, Wilcox, and Fazzino, Ranking Members Kissel and Fishbein, and to the other distinguished members of the committee. My name is Patrick Fahey, and I first want to say that it's truly an honor to be before you today. I want to thank Governor Lamont for putting his confidence in me through this nomination, and I'm grateful to the governor's staff for guiding me through this process. I was born and raised in central Massachusetts, the youngest of 6 children, and I permanently relocated to Connecticut after attending law school here. Following law school, I worked as a law clerk to 3 judges, a magistrate judge, Judge Thomas Smith, a district court judge, Judge Dominic Squattrito, and a circuit judge, Judge Ellsworth Van Graafland. This unique experience exposed me to all levels of litigation, from work at the trial court and the minutiae of presentments, arraignments, and plea hearings, to complex trials in both civil and criminal cases, as well as to appeals. At every level, I worked closely with the judge and came to have a deep understanding of the hard work entailed in judging, the day-to-day aspects of administering a docket, and the critical need to make decisions efficiently in order to move matters forward for the benefit of the litigants. I also gained a solid appreciation of the fact that while day-to-day aspects of court can become commonplace to those that work within the court system, that is not the case for those who are exposed to the court system as litigants. For those individuals, an experience in court is likely their most involved interaction with their government. It can be stressful, overwhelming, and frightening for those individuals and their family members. And it is essential to our system of justice that they know that the system treats all fairly. After clerking, I started private practice at Shipman & Goodwin in Hartford, and I've been at that firm for my entire career. My practice has focused on representing both plaintiffs and defendants in complex civil disputes, including intellectual property matters, business disputes, privacy disputes, educational disputes, and fiduciary litigation in state and federal courts throughout the country. My clients have been individuals, business entities, and local boards of education. My experience has involved all aspects of civil litigation, including pretrial, trial, post-judgment, and appellate litigation. I've had a varied and, by most objective standards, a successful career in private practice, and I'm immensely grateful to my wife, Mary, who's here with me today, and our two children, Thomas and Lauren, for their support. As I grow older and I see the world more through the eyes of our children, though, I feel I can and should do more for the community in which we live. It is that point of view that has led me to want to serve as a judge. I have great respect for the position. I am cognizant of the immense trust and responsibility placed in our judges. I'm humbled and grateful for the nomination, and if confirmed, I'm eager to be of service to the people of Connecticut. Thank you for your time, and I look forward to answering your questions.
Thank you. Representative Fishbon.
Thank you, Mr. Chairman. I thank you for the time and attention that you gave to the backup that's before us here today. It's very comprehensive. I also do appreciate, we as lawyers, through law school, through our training, our experiences, gain tools that normal people don't have. And, I appreciate the work that you did for the Sandy Hook family. It's listed under your pro bono, because that's something that normal people wouldn't be able to do. And I appreciate that you were able to help that family and do it so that they could get the closure that they needed. I'm very happy that you're before us here today. So thank you, Mr. Chairman.
Thank you, Representative. Representative Fazzino.
Thank you, Mr. Chair. Attorney Fahey, good to see you. And congratulations on your nomination. We've had the pleasure of practicing together for, unfortunately, not as much time as I would have liked. And I say that for two reasons. The first thing that comes to mind when I think about you as an attorney and a practitioner is your commitment to ethics. Every conversation that we have had surrounding ethics within the context of our office and even beyond that centers around you. And I just want to say on the record how much I admire your commitment and your reverence to the ethical practice of law. We need that in all of our judges, especially right now. The second thing that I really admire about you is your commitment to mentorship. When I started out at Shipman not that long ago, I asked my mentor who he seeks out for advice, because if there's one thing I know to be true about the practice of law, it's that we always need to rely on our peers, whether you've been practicing for a month or whether you've been practicing for 40 years. And my mentor said that you were the first person he always calls. So I just wanted to give you the opportunity to speak to how you hope to continue that passion for mentorship that's so needed in our practice right now, not just for now attorneys practicing, but for members of the bench as well.
Well, thank you. Working at a large firm like Shipman and Goodwin, you do have the opportunity to serve as a mentor. Both, we have official mentoring programs where you get assigned as a mentor and a mentee, and just the unofficial day-to-day interaction with other lawyers that lends itself towards a mentor relationship that's really crucial to the collaborative practice of law. And that's something that I was trained to do, and I'm glad to hear I have a reputation for doing it well. I take a lot of pride in it. In terms of going forward, it does, I'm not exactly sure how to continue, to be honest, how to continue that role, but it's my goal and my obligation to do that. I can see the opportunities that are presented as both, seeking out mentorship from other more experienced judges and taking advantage of those relationships to the extent I can, but also serving as a mentor, or at least a willing listener to the bar, and to the people that appear before the court. To that end, it's my goal to remain involved in bar activities, to remain accessible to the bar at large, both to continue that mentoring scheme, but also to help myself stay humble.
I really appreciate that answer. And, from a practitioner standpoint, certainly it's our firm's loss, but more importantly, it's the gain for the state of Connecticut. And I just have every confidence in you, not just as a practitioner, but more importantly, as a person. And it's been a pleasure practicing with you, albeit for a short period of time, but we wish you the best and congratulations on your nomination. Thank you.
Thank you.
Thank you, Representative. Senator Gadkar Wilcox.
Thank you so much for being here today and for your testimony. I wanted to highlight your clear commitment to pro bono work, which isn't just sort of a one-off instance or something you've done for a number of years. It seems like you have a very intentional commitment to pro bono work, which I very much appreciate. And I just wanted to ask you about, what drives that commitment and what do you think should sort of be the standard for other attorneys? Because it's not always easy to find time to do the pro bono work, but it's so critically important given, the shortage and the issues that we have in terms of access to justice for so many in the state. So your philosophy on pro bono work for other litigators and also what drives you. And I just want to commend you on your clearly intentional commitment to that pro bono work. Thank you.
Oh, well, thank you. All of us as lawyers have an obligation to do some pro bono work, and that can take a lot of forms. When I was first starting out, as you sort of alluded to, it's hard when you're involved in a larger firm or a private practitioner to find the access and the time and the ability. And all of those things are almost equally important. So I remember looking for opportunities early on, and I read this article about pro bono work, and there was a comment from a judge on the DC Circuit. I think his name was Title. I'm not sure how to pronounce it, but he said, look, the best thing you can do to support your pro bono obligation is to pay people that know what they're doing to provide pro bono services. So I became involved in Greater Hartford Legal Aid. And that's sort of where I saw, my contribution for a long time is raising money for Greater Hartford Legal Aid. And then, along the way, other opportunities presented themselves. And as I got more established in practice, I had more opportunity to give my time to those activities. But in the back of my mind, the whole time, my commitment to the financial piece, funding people who know what they're doing, has been really what's motivated me. And then I've been lucky enough to have been able to help individuals along the way.
Thank you for that. I very much appreciate that because it is very hard particularly as a young lawyer, a young litigator in a large law firm in particular, to find the time to do the pro bono work. I remember being very committed to pro bono work, but having just to work much more than everyone else because I had to also meet my billable hours. And so that's quite a struggle. And yes, creating ways where we actually have paid representation and access, improving our access to justice is absolutely the way forward, I think. And thank you for your commitment to that and your commitment to pro bono work as well. So thank you very much, Mr. Chair.
Thank you, Senator. Comment or question from other members of the committee? Comment or question? If not, I will ask you my question about accountability. But I want to be clear because unfortunately, folks have answered this question oftentimes in a way that is not an actual answer to my question. So I'm going to reframe the question. I would like you to speak to me about your structured, personal framework for holding yourself accountable without external supervision or other forms of external accountability.
Senator, that's a hard one to answer because, in all honesty, my internal structure for accountability really depends on the people around me. I work very closely with my associates and my partners. I depend on them to correct my course. In addition, and as much, probably more than I depend on myself. Lawyers work really hard. We have hard jobs, and sometimes you have bad days. and you have to be responsive to your internal signal. My worst days are when I feel like I'm not acting like myself. I take that very seriously. I take a step back and I try to correct where I'm heading emotionally. And that generally works. But short of that own sort of internal check, I really do depend on the people that I work with and collaborate with to help me deal with the difficult parts of being a lawyer.
Yeah, and I'm gonna follow up because I don't want to be unfair in asking that question. So I think having external folks involved in a system that you set up versus just having them adjacent to you and they may provide you with feedback are two different things. So when I talk about this, I'm saying it should not depend on who happens to be around you, right? It shouldn't be the kind of thing where I have great people around me who might feel themselves that they can provide me with feedback. It shouldn't be something that you didn't have a hand in setting up, regardless of who those individuals happen to be. And it shouldn't be like many of the people have answered in the past that they have to take out the trash at home, because that's not a good answer. So with that in mind, does that change your response to me?
A little bit, Senator, because I happen to have great people around me, but it's not dependent on having great people around me. What's important to me is the open channels of communication. What's important to me is that every member of my team has a voice and is heard and is able to comment on how we're acting as a team, where we're going, what our goals are. Are we achieving those goals? So it's more of the collaborative process than the I have great people around me. It's the approach to practicing that makes sure everybody involved has a voice and is heard. And that's the piece that I think has to translate for me, if I'm fortunate enough to be confirmed. How do I ensure that the people around me have a voice and are heard? That's a challenge. I mean, one of the things that I've thought about in terms of where I am and where I'm going, having worked closely with judges in the past, is how isolating the job can be. It can become a very siloed, solitary existence. And I've resolved to fight that. I mentioned before, a goal is to become involved and stay involved in bar activities so that I'm accessible, so that I never forget that my feet are made of clay. That's the best I can do.
I appreciate that answer. Further comment, question from members of the committee? Further comment or question? Seeing none, thank you for joining us. Congratulations on your nomination.
Thank you.
Okay, next we have Felice Gray Kemp of Hamden. And when you are ready, raise your right hand. Do you swear or affirm, as the case may be, that the information you will provide to the committee will be the truth, the whole truth, or nothing and nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide us with your testimony, your statement.
Thank you. Good morning, Chairman Staffstrom and Winfield, Vice Chairs Flexer, Gatra, Wilcox, and Pizzino, Ranking Members Fishbein and Kissel, and distinguished members of the Judiciary Committee. Thank you for the privilege of appearing before you today. I am deeply grateful to Governor Lamont for entrusting me with this nomination. My relationship with Connecticut is both professional and deeply personal. I arrived here in 1987 to attend college, but my connection began years earlier. I grew up in North Carolina and spent part of my summers here with my aunt and my cousins. Even then, Connecticut felt like home, and that feeling has only deepened over time. I went to college, built my career, raised my family, and found community here. I attended Yale University, UConn Law, and later earned an LLM in taxation from Boston University School of Law while working full-time as a tax attorney. I met my late husband, Herbert Kemp III of Westport here. He was a corporate leader who dedicated the final years of his career to nonprofit leadership. In my own service, I co-founded the Aurora Foundation for Women and Girls, which recently marked its 25th anniversary. From a blind date to a 32-year partnership grounded in shared purpose and devotion, Herb and I were blessed with our son, Evan, who is here with me today. Evan's life reflects what Connecticut makes possible. He was born after care through UConn's Center for Advanced Reproductive Services and spent the first 20 days of his life in the NICU at Yale New Haven Hospital. With early intervention through the Birth to 3 program, he overcame significant challenges, including being nonverbal. Today, he thrives as an A student and a member of the varsity swim team. For 30 years, I have handled complex, high-stakes matters requiring sound judgment, sensitivity, and integrity. I've been recognized for assessing situations quickly, prioritizing effectively, putting people at ease, and resolving difficult matters with clarity and fairness. My experience as commercial counsel is directly transferable to judicial service. While corporate counsel often focuses on structure and compliance, commercial counsel operate across the full life of a business, addressing employment, contracts, real estate, regulatory matters, and more. In that role, I've been responsible for fact-finding, analysis, interpretation, and decision-making, often in collaboration with others, while upholding the law both within and beyond the organization. I've served as both an advocate and a steward of the law. Across my career, I have consistently taken on unfamiliar areas, closed knowledge gaps, and approached each new challenge with discipline and humility. No judge comes to the bench having experienced everything the role requires. That is true of every successful Connecticut Superior Court judge. I welcome the opportunity to draw upon Connecticut's strong system of judicial training and continuing education, beginning with judge school. I approach others as I was raised and am wired, with authenticity and respect, regardless of background or position. Even in adversarial matters, I have built lasting connections and earned the respect of opposing counsel. In addition to my practice, I have remained committed to service through teaching, mentoring, and public engagement here in Connecticut. At this stage in my life, I am drawn to a singular purpose: to serve the people of Connecticut as a judge. If confirmed, I will approach that role with humility, integrity, active compassion, and an unwavering commitment to fairness and the rule of law. Thank you for your time and your consideration. I welcome your questions.
Representative Fishbach.
Thank you, Mr. Chairman. Good morning, ma'am.
Good morning, sir.
Thank you. Nice to see you here today.
Thank you.
When did you go through judicial selection?
2009.
Okay. And is there a reason why when you filled out your questionnaire, you did not know that
Yes.
year?
Yes, there is a reason. The reason is that I had kind of cleaned my office of various things, among them the letter confirming the date. And I was awaiting a date from the governor's office, which they provided, but after the deadline. It was not an intentional omission. I just wanted to make sure I got my paperwork in time, but it was 4/16/2009.
Okay.
Apologize for that.
So that was a very long time ago. I guess we'll leave that as it is. Have you ever been in a courtroom?
Oh, yes, frequently.
Okay.
And yes, it was
As a practicing lawyer?
Oh, no, not as a practicing lawyer,
Ah.
but as an attorney managing external counsel. I have grown up in corporations. I have been an in-house attorney my entire career, or representative of commercial organizations for the most part, and entrepreneurs. And so I have not argued a case, but I have worked shoulder to shoulder, in fact, identifying and developing strategy with attorneys who represent my clients.
And when was the last time that you worked shoulder to shoulder on a case?
That would have been June of 2025.
And in what state was that?
That would have been New York.
Okay.
Mhm.
And when was the time before that?
I'm sorry?
When was the time before that?
In each of the roles that I've had, there has been some significant litigation. I'll say closer to Connecticut. That time frame would have been around 2016.
Okay.
Mhm.
So have you ever worked shoulder to shoulder on a case in Connecticut court?
Yes,
Okay. And when was that?
that would have been the 2016, the Lego case, I think that I referenced.
2016, you said?
I believe so, yes.
Okay. And what was your particular involvement in that case?
It actually encapsulates or is a good example of what I did and do as a counsel to corporations is that I identified an issue that was part of a commercial discussion where an adversarial party was misappropriating intellectual property. And I raised that from the commercial context in a business meeting, and then proposed that we do the fact finding, the analysis to determine what opportunities we might have to pursue litigation, worst case, but to reach a commercial resolution to have that stop. At the time, the belief was that the theory was possible and interesting, but might not have been successful. I advocated for it, and the case was ultimately won once the decision was reached to pursue it.
Okay, but you didn't file that?
No, I worked with external counsel to develop, to review, to input to the motions that ultimately resulted, yes.
Okay.
Mhm.
Now, your backup indicates that you passed the bar in February. No, you passed the bar in 96,
Mhm.
but you didn't get sworn in until 97. So what was the reason for that?
I started my career at Arthur Andersen, and they had, for every new attorney that joined, there was a commitment to attend a training in Illinois, and that date was not movable. And of course, Murphy's Law being what it was, hope I don't offend anyone named Murphy, it convened with what would have been the swearing in date for my class. And I made that reference just to make it clear that I did pass bar on first attempt, but because I could not attend the swearing in with my class, I had to be sworn in chambers with a judge just by myself.
The backup also indicates that you've maintained a New York license to
Yes,
practice law since 2019.
Yes, sir.
And what was your reason for acquiring that?
Living so close to New York, and at times the stresses on the Connecticut economy for roles such as I had and pursued were such that it just made economic sense to remain in Connecticut. And if and as the right opportunity, because I largely worked for multinationals, presented itself, to take an opportunity in New York if it became necessary or appropriate or available, where I could continue to be working on multinational, multi-state issues, including Connecticut, but a condition for many of those roles was to have a New York bar.
Now, we asked you during the last 10 years about your work in court. I mean, I'll says during the last 10 years, what percentage of your court appearances were in, and we give you federal court, state court. You told us in the backup that 5% of your court appearances were in federal court. That's the backup says.
What I communicated or tried to, I apologize if it wasn't clear, is in prefacing the percentages to the type of court, I declared and shared that I had not been a first chair, that I had actually not practiced in court as an in-house counsel. I did not appear in court was my first sentence, just to make it clear that the estimates on the litigation matters that I was supportive of building, with external counsel who actually presented clients, consisted of this percentage of my work. So what I'm communicating here is that I was not approaching the bench with the case, but I was working, as we talked a moment ago about, at the shoulder to shoulder level in my workspace of the work I did. About these percentages of them led to these types of litigation.
Now, you mentioned the phrase first chair, right?
Mm-hmm.
You didn't file an appearance in any of these cases.
No, absolutely not.
So you weren't any chair.
That correct. The corporations and the employers that I have do not allow in-house counsel to take that. So I'm the in-house chair, not a first chair to the bench.
Yeah. So usually when people haven't practiced in court, the answer is 0. And I'm just trying to figure out,
I understand. It's not, I'm not trying to be sleight of hand or wordplay. What I was attempting to do in that clarification was to kind of connect the thought and the nature of my work to the dispute resolution that ultimately is courtroom by comparison and timeline and specifics rooted in the nature of the in-house work I did, not to present myself as a counsel, such as a trial counsel. That was.
I understand.
Yeah.
You know, the reason why we asked the question is we want to know, are these real I mean, not real lawyers, I'm sorry.
And that's why
you know, we're looking at people to go on the bench. Do you have any experience being in a courtroom and actually doing the job, right? That's what we're looking for. It's not the, well, I was in the hallway and we chatted sort of stuff. Or, you know, the lawyer who was actually doing the case reported back to me and we talked about strategy. That's not what we're talking about. But then for number 2, for state court, so you said 5% federal court, you said 5% state courts. So I'm like, well, okay, where's the other 90%?
And that's what I'm referring to when I say of the 100 points that were my job in the past 10 years, 10% of it gets to a court. The other 90% of it is the dispute resolution, business architecturing to be compliant with law, risk mitigation, all the things that a commercial counsel does.
Okay, so assuming that to be true, the next question asks, what percentage of your court appearances were in civil or criminal? And you say 98% civil and 2% criminal.
Of the 10%, yes.
Okay, well, that's, what was your, because you've been in-house counsel, that's basically your resume.
Yes.
What was your involvement with criminal matters?
There was a recent case here in Connecticut where there were some aerospace and defense manufacturers who were alleged to have colluded to fix wages. And so it was a theory under an employment law brought by the antitrust division that they were violating commercial practices and it was inappropriate. And there were people who were called to defend themselves for criminal conduct related to that. And so even though it was a commercial case, there were individuals who were named as defendants and had been indicted and were named for criminal activity. They did not go to jail, but and they were not found guilty, but that is the criminal piece.
And what was your involvement in that? It asked specifically what percentage of your court appearances. So
yes, so it was the supporting of the fact-finding, development, building the case with the external counsels who represented our interest to the judiciary. And I heard your point too about whether or not you can do the job. So I just want to reiterate that this was not intended, and this is why I communicated that this is relative to in-house work and not actually presenting as a trial lawyer, that there are other ways to practice law, and that was how I did so in the vein of explaining my courtroom experience and my trial experience.
in all candor, though, I really have to pause when the 2 words court appearances, I think is quite clear.
Okay.
To not only practicing lawyers, but a person on the street. And it's being, you know, anyway, I'll go on because I got a lot more here.
No, I bet. Yeah.
So then question 15. Well, let me ask you this.
Yes, sir.
Did anybody assist you in putting together your backup?
My backup?
Yep.
Oh, these materials. Not really. No, I just know I had.
I mean, not really. Either you did it yourself or somebody else.
I did it myself. There were people to remind of deadlines and delivery and and such. So when I say assist, yeah.
So everything that's before us, you put together on the paper.
Yes, I did, sir.
Okay.
Yes.
Question number 15. Please provide the names of any firms, offices, part or full-time legal employment associated with since admission to the bar and the years of each association during the last 10 years. Please include the general scope of your practice at the firms. That's
Yes,
what we
sir.
ask for. Your answer is titled Summary, and it goes like this. Award-winning attorney with nearly 30+ years experience with transactions, dispute resolution, compliance investigations, internal inquiries, crisis management, risk mitigation, and strategy across global regulated industries. I'll read the question again.
Yes, sir.
Please provide the names of any firms, offices, part or full-time legal employment associated with since admission to the bar.
I did. Yes. Yes, sir. Yes.
Okay.
So the summary is in response to the please include the general scope of my practice. So that was the summary of what I'd done for the 10 years. And then if you look down to the penultimate line, certain professional experience, that's when you see the actual employers and descriptors of the 10 years. So unified law group, on to the next page.
Question 19, we ask about your public offices and positions and the years of service.
Yes, sir.
Can you look at your answer to number 19?
Yes, I was a regent for Connecticut State Board of Regents.
And you didn't give us the dates of service, did you?
No, I didn't, sir, but I can do that right now.
Well, I mean, I'm trying not to be difficult, really trying, but is there, well, I'll go on. Question 22. Please describe any pro bono work you have performed. Your answer. Support boards with legal inputs, etc. What does that mean?
What that means is that some of the boards on which I sat required legal counsel review, etc., and did not have their own attorneys, nor did they have budget to reach out to pay attorneys. And so I provided some amount of legal support to some of those boards.
So those are boards that you're sitting on as a volunteer?
Yes, sir.
Okay, so
Yes.
it's not like you're reaching out to the local Boys and Girls Club,
no,
you
sir.
know, it's, you know, people get put on boards because they have an acumen, right? You know, we take somebody from the manufacturing industry and the legal industry and the finance industry, and the hope is that they collaborate and they each bring their tasks. It's not pro bono work per se. You know, pro bono work is, you know, in my opinion, and I've done this, you pick up the newspaper and you see that somebody's house is burnt down and you find the family and you give them some help as a lawyer. That's pro bono work. But anyway, I'll go on.
And I, to your point about people inviting you to boards for certain of your capabilities, the boards that I list on 20 were not boards in which I was engaged or brought into because I was a lawyer necessarily. So I was brought in because of relationships, connections, affinities for particular subject matter, and typically, you know, not brought in to be the lawyer or a legal person on a board, just a person who is interested and engaged.
What's Unicorns LLC?
I'm sorry?
Unicorns LLC?
Unicorns LLC is an LLC that I created to support the work that I do for different stakeholders, whether it's the career coaching or provision of legal services outside of the context of my employment. And sometimes I would provide those services over and above having been an employee of, say, a Lego. This is a business that I started as a separate line of business to support my family.
So when I looked up your juris number on the judicial website, it indicates that at least through that system, that the address is confidential.
Yes,
And what is that reason?
that is because Unicorns LLC is the vehicle through which I deliver those services that I mentioned, and the address is my home address. I have experienced some very interesting challenges being a woman with my address on the net, so I try to keep that to a limit.
Okay, well, after I clicked on that one, I went to the Secretary of State's website and got your address. So I don't know of what protection. But anyway, your time on the Board of Regents was when?
It was 2016 through 23.
And did you term out or did you
I
resign?
turned out, sir.
Okay.
That's right.
And were you there when the whole the vote on Cheng happened?
No, I was out at that point.
Okay, somebody had asked me about
When you
that.
said the vote on him for his dismissal or to hire him, I should apologize.
Well, to continue to pay him $450,000 a year.
No, I was not there, sir.
Okay. So then your resume. Well, right now you work for Unified.
Yes, I'm self-employed.
Okay, and what is your role there? You're self-employed? I thought you worked for Unified.
So I'm self-employed because Unified Legal is a fractional general counsel organization. So we provide legal services to companies who cannot afford their own legal departments. We operate as an adjunct to them. And so each general counsel that provides support to Unified and through Unified is self-employed. So Unified is the group through which we receive clients, we deliver marketing and other connections so that we can market not only our abilities, but the Unified brand. But each general counsel that works through Unified is self-employed.
And what is your role with them presently?
I am a general counsel within the group. And as we look to scale and do additional things such as in the AI space, I'm an advisor on that scale out and that development.
Okay, because I looked at your LinkedIn page and it says, I mean, I guess you created this, that you transitioned to being that you were a GC, but in January of 2026, you transitioned to be a strategic advisor. So is that different from being a GC?
Yeah, it is. It was GC singularly. And then the strategic advisor is to our new lines of business and other things that we're exploring over and above singularly fractional.
And when were you at Scient?
I was
CYIENT.
I was in Scient in 2020.
Okay. And is there a reason why references to Scient have been excised from your backup?
No, there's no excision of Scient to the backup. When I transitioned from being an employee there, I wanted to go in as my fractional position as my self-employed. They did not want that. So I went in as an employee and determined that I preferred what I was doing and kept them as a client.
So where in your backup do you tell us that you work for Scient?
It's in the descriptor on line 2 of Unicorns LLC, which was my last engagement with them.
If you look at question 15, right?
Yes.
And going on to its top of page 5, you give us your employment resume. There's no reference to Scient there.
In all of my materials that I submitted, and I apologize, but in all of my materials I submitted a resume that had Scient listed there.
Okay, but the backup that's before us for today's meeting, you agree, has nothing about Scient.
No, they would be under Unicorns because
you agree with me. There's no reference to Scient.
Yes.
And also on your LinkedIn page, there's no reference to Scient.
Not as a separate employer, no.
Okay. And Scient did a press release about you being appointed as their general counsel. So
Yes, they
this
did.
isn't, I mean, Unicorns LLC is you.
Correct,
Scient is somebody else.
correct. And then, and help me if, please, if I'm not being clear there. I had wanted to provide services through Unicorns LLC. This Indian corporation preferred and had no context for that and preferred me to be an employee. I did it for 6 months and then reverted back to services through my LLC.
No, I understand. I mean, this is one of the problems with somebody who hasn't gone through judicial selection in a very long time, is judicial selection would have gone through all of this.
Okay.
But I'm faced with having to dig in a 12-hour period.
I'm sorry, sir. And
No, it's not, I'm just dealing with what I have. On your LinkedIn page, with regard to Unicorn, you wrote, or typed, realization of a career-long dream of full-time entrepreneurship only upon accepting GC rule at Castle, which we'll get to,
yes,
to return to full-time employment with truly inspirational, groundbreaking leadership. I'm trying to put that together. We've heard today, Attorney Doolittle talk, I've always wanted to be a judge, and I'm looking at this, career-long dream of being an entrepreneur. How do I put those two together?
I can help you. I have had in my experience and my life plans professionally, a series of steps and experiences that I wanted to achieve before I had the privilege of being in this room and having this discussion. And in the corporate life, I had I don't like the word bucket list. It sounds a bit more terminal than it needs to be. I had a life list of things that I wanted to achieve. I wanted to work for myself. I wanted to be a general counsel, and I wanted to capstone being a judge. So in the milieu of a corporate counsel, commercial counsel role, that was the dream. But the ultimate dream is to become a Superior Court judge. So that's where that hangs together. It's not the singular dream, it's a dream. And I had accomplished that.
So when did you get to Castle? And just for the record, it's Caastle. When did you start working there?
I started working there March of 2020.
March of 20, when?
2020, I believe, yeah.
Okay. And you were the
Sorry,
general.
21. We started discussing in December and I started March 21. Sorry.
Okay, March of 2021.
Mhm.
And you were the general counsel there.
Yes, sir.
And were you the top lawyer for the company?
The top commercial lawyer, the CEO at the time was a serial entrepreneur, and she worked with a law firm and one particular partner at the firm for her corporate and governance business work. I was the general counsel, the top lawyer for the operations of the business, the commercial versus the corporate. I was not responsible for corporate documents, foundational materials, shareholder interaction, sales.
Well, who as a lawyer was in charge of that at Castle?
That was the third-party law firm who had been with the CEO for a number of years.
Okay, but you're in-house. You're the
Yes,
top
I'm
in-house counsel.
Yes,
Was there some sort of wall between you?
100%.
Okay.
100%. And that was made clear during the interview process. When I asked exactly that question, I was like, what are the roles or responsibilities? What are you doing for governance? How are you keeping cap tables? And I was told, and all the officers experienced the same, that work would be with this external counsel with whom she had these relationships and had worked with a number of years. And she wanted us as the officers to focus on the operation of the business, and that she would deal with the corporate counsel to do those other things.
So you had nothing to do with the audit that was done at Castle?
Absolutely not.
It's
And
a little weird for general counsel to not be involved in the audit at all.
here's where I was involved, and this is a huge thing to know, because it is difficult to understand without this simple foundation built off of the fact that the Castle structure was financing, governance, and the things that ultimately became problematic through the corporate counsel who worked directly with the CEO. The rest of us, CFO, COO, myself, we were operational, and we did see proper, I will not speak to them, I did see proper audited financials as they were given to us by our providers. The challenge and the difficulty that happened, and I want to be very careful in what I say here, because this is all public record, but it's very easy to misunderstand and not to speak clearly on. The issue was never that we did not see the financials, that we did not see the audited reports within the corporation. The issue was that our CEO, as founder-in-chief and investor relations-in-chief, presented different documents than we had signed off on, seen, reviewed in the corporation, in rooms that we were not in conversations that we were not a part of. And that is one of the reasons why my name appears nowhere as a defendant or a party of interest or subject to that investigation, because I will speak only to my own case, saw what was in the company as valid and accurate, having no knowledge that other things were being communicated.
Well, and you know, just I think you and I know what we're talking about. There
Correct.
was an investigation by the federal government, and that there was a $300 million fraud scheme discovered, and the CEO pled guilty to certain things. So you get, and the reporting evidently started in 2022,
Mhm.
which is about a year after you got there,
Mhm.
the fraudulent reporting. You stayed there after she pled guilty and worked with the Chapter 7 liquidation of the company, right?
I just would like to, I don't want to be didactic here, but there was no fraudulent reporting. The charges against the CEO are fraudulent inducement. She created, by her own admission and fact, documents that were not reflective of what the organization saw. There was no fraudulent reporting. There was fraud on her individual part in inducing investment.
Well, the press release from the Fed says a little bit differently. It says, when confronted by an audit firm in October of 23 about transmitting a fake audit to an investor, she lied and falsely claiming that she created the fake audit in connection with a lecture she gave at Princeton, yada, yada. But essentially, the way I get it is that the audit was showing that the company had about $300,000 in revenues when they only had like 300 million in revenues when they only had about 15 million in revenues.
That's the fraud that she was alleged to have committed on her own. That was, I learned, and my colleagues learned of this at the same time it hit the press. That was not a corporate action. That was a CEO action. That's what we're saying. And we did not know that.
I was just laying out the timeline. You got there in 2021.
Mhm.
She starts to, or at least she got caught fraudulently putting out documents in 2022, convicted 2023. Well, actually, that's when the investigation started. She was convicted 2026. But that's when the investigation started, and then you were part of winding up the company for the Chapter 7, right?
Yes, I was part of a little more than that, and I think it bears repeating that it is amazing what people with will and computers can do. And but for an errant communication, we would not know of that to this point. Her ability to fundraise was legendary. All the right questions were asked. We all did what we were expected to do. We were not in those conversations where she is presenting, by her own admission, manufactured documents. So when it came to all of our attention at the same time, or at least my attention, and timing may have been slightly different for others, I was tasked with a choice. I could leave things as they were, or I could try to right the ship. It was not my doing, but I felt as a leader that two things. I wanted to make sure that we had a company worth saving, and my leadership wanted me to stay. And I did not believe that leaving in the course of all these unanswered questions, which could have implicated me, was either wise or the right thing to do for the business. So I did stay. We tried to continue as a going concern, but since the CEO was so inextricably linked to the business, that we couldn't save it for any number of reasons. I'm sorry, sir. Yes.
Maybe take off my mic so we can talk. Your writing samples, do you have them with you?
Yes.
Okay. So just want to focus on sample number 3. First of all, none of them are any like legal pleadings. They're
No, that wouldn't be.
they're like letters. Number 3 up top, left-hand side, it says letterhead.
Yes.
Right. You had mentioned a case in 2016 that had to do with intellectual property. Is that where this letter comes from?
No, sir. This letter is an example of a distillation of the legal principles around IP infringement against an employee who was misusing certain intellectual property of a former employer. And through the law supporting my client's right to do so, this letter distills a warning and reminder to that person that they are not to misappropriate that IP. So this is meant to be an example of kind of breadth and depth and scope of some of the work that I do, how it gets distilled in a commercial context to facts, law, action. And yeah.
And did you use this letter at some point?
Yes.
Okay. You took out like identifying.
Yes, I had to redact it for the client.
Okay.
Yes.
And did it, and you did this letter?
Yes, sir.
Okay. So, in the, when was it used? Because you took out the date, which I don't know why somebody take out the date.
Okay, so this would have been used in 2025, 2026, yeah.
And in the subject line, the cease and desist, there's a misspelling. Ventral.
No, that is, it could be a misspelling, but I played with the name of the actual client.
Okay, but that's the only place you did that. Everywhere else you took it out.
Okay.
So the one case that you reference in here, the More Life case.
Yes.
Did you read that case?
Yes, sir.
And what aspect of common law does that case have to do with?
It has to do with contracts and trade secrets.
Well, that's the portion, the Uniform Trade Secrets Act, right? But you specifically say, reference common law and the More Life case. Did you read the More Life case?
Yes, sir.
Okay. And if I was to tell you that the two words common law do not appear in the More Life case, would that be of news to you?
No, it wouldn't be, but it would, my understanding of the case was that the principles that it espoused, the communication in it made that it directly applicable to the facts that we were disputing with this former employee.
Ma'am, who is Johanna Harrington?
Johanna Harrington is another of the general counsel with Unified Law. We collaborate on different things. She's more of a corporate lawyer. I'm the commercial, and we buddy up.
Is there any reason why when I ran the metadata on this document that it indicates that Johanna Harrington is the author?
Because we wrote it together.
Ah,
But
not what you said before. I asked you if you created this.
yes, I did. I did. I created it with Johanna. She asked me to write it. She was the face to the particular client. She then edited after, and then I went in and we closed it out together. So yes, I did write it. We wrote it together. That's how Unified collaborates.
What have you, when Attorney Beckham came before us earlier today, there was a lot of questions about his not ever appearing in court and what he has done to learn what a court is like.
Mhm.
What have you done?
In addition to having spent a fair amount of time in court, I want to say in 2000, when my late husband was a juror for what would have otherwise been, had we the death penalty, a capital murder trial in New Haven. There was a bodega shooting and some folks passed. I living close to New Haven over these years and knowing that this was a goal of mine, I would periodically go and listen and watch Short Calendar. And then also too, having the availability of video. I, of course, watch what I may from CTN and other resources, but I've been in New Haven courts with some frequency or some extended of time.
When's the last time you saw a Short Calendar in a courthouse?
It's been a number of years.
We haven't had Short Calendar in a number of years.
But that's.
Yeah.
I thought you said, when do I go to the courthouse? It's been 3 to 4 years since I've been to a courthouse.
Okay. All right. Thank you, Mr. Chairman.
Mm-hmm.
Thank you, Representative. Comment or question from others, Representative Staff.
Thank you, Mr. Chair. Attorney Greg-Kemp, on that last dialogue about Short Calendar New Haven, is there a particular judge that you have observed that you would like to model your time on the bench after?
I, having lived in and around New Haven for many years, have really admired the career of Justice Luby Harper. There are other judges who I know who are relatively newer to the bench. I admire and respect their contributions. They're senior judges as well, such as Judge Juliet Crawford and Justice, yes, of course, Justice, I'm sorry, I'm a little thrown by that last exchange, but yes, there are other judges who I've seen in practice and know by reputation and video that I'd like to model as being measured, kind, fair, and knowledgeable. And when given the chance to see them, which is challenging to do when you work, so you have to take the time that you can and as you can. It's been a privilege to watch them.
There were a bunch of questions about your questionnaire. Well, let me just ask this.
I'm sorry, I lost the last.
I said, there's a bunch of questions about your questionnaire. Let me just ask this. At the end, we ask people to certify that it's true and accurate to the best of their knowledge and belief. Do you believe your questionnaire was true and accurate to the best?
Yes, sir, I do. I do. And one of the challenges, and it's not a complaint, but one of the needles to thread is how not to be so verbose that you lose people. So I'm trying to both condense what could otherwise be reams of paper that I know people may be too busy to read, as well as message and experience that I was hoping to come through as that my diverse experience in a place and a role other than a litigator is directly transferable to that. And in doing so, I clearly had some room for opportunity there.
Well, no, I think you went exactly where I was going to go, which is that, as I read through your backup here, I mean, I certainly prefer, take question 14, for example, right? I mean, I think you made it clear that you were an in-house lawyer for
Thank
most of your
you.
career.
Yeah.
I mean, I don't think you were trying to deceive us in thinking that you had, tried the 40 cases to verdict. You
No.
clearly have not tried 40 cases to verdict. I think I certainly prefer some sort of explanation about your background and what you've been doing in your career, as opposed to at least one other nominee we've seen in here that just put not applicable. I'd rather this than NA, right?
Thank you.
I think it provides at least some context and some understanding of what you've done. I mean, whether that satisfies people or not, that's a different question, but at least provides context. So I thank you for being before us today. Let me just ask, you were also asked sort of about this pro bono question, I think, which is number 22.
Mhm.
When I was a young lawyer, one of the things my mentor talked to me about was getting involved in nonprofit boards, right? Because there's a couple reasons for that. One is nonprofit boards, particularly, art museums, YMCAs, Boys and Girls Clubs, right? They're always looking for a lawyer to go on the board. The reason why is because they want to know when they want somebody who can think critically.
Respect.
And they want somebody, when they're sitting around that table and the conversation starts to go a little off the rails, can bring the conversation back in and say, not that I'm your lawyer here, but you might want to consider whatever.
Correct.
And I'll be honest, in my career, I've done a lot more of that type of work than I have true quote unquote pro bono work, in the sense of representing a client who's being evicted out of their apartment or something like that, But I think the mission and the goal of whether it's representing a client facing eviction, or whether it's spending your Tuesday nights once a month at a board meeting, is still the same net result. It's service back to the community, and it's using the skill set and the degree that you have in order to better your community. And it seems like to me, somebody who's got a background in corporate governance is probably more suited to sit on a corporate board and provide free guidance than maybe to represent somebody being evicted out of their apartment. Yes?
Yes, sir. I try to use the skills that I have in developing new skills and build off of that. And much the same way that I've met thousands of attorneys who have transitioned from different areas of law, or from law firm to in-house, but I've only met 3 who were tax attorneys who became general counsel. And part of that is through exactly what you said. It's this notion of being able to see, think differently, draw connections that might not be obvious to other people through the words or the concepts that they're trying to communicate, and just add value and diffuse difficult situations. So yes, and thank you for that.
So the other thing I wanted you I don't know that you've had a chance to comment on, that I wanted to give you an opportunity to comment on, is oftentimes when we're sitting up here looking at folks to put on the bench, as somebody who is in private practice, I'm always concerned about putting judges on the bench, that those individuals are going to understand what it's like in private practice, that they understand that lawyers who are walking into a courtroom not just have lives, but they've got clients they're responding to, that they've got multiple different clients who they're trying to juggle competing concerns for, and what that means in terms of the private practice of law. I mean, I've always said, being a government lawyer is easy, right? I mean, you got one client, you got a town, you got the state, you got whoever, right? When you're in private practice, when you're at Shipman and Goodwin or Pullman and Cumley, I mean, you've got dozens of clients, and you're trying to juggle that when you walk into the courtroom every day. And you've also got a corporate, maybe legal, in-house legal department that you're responding to. So do you want to comment on how you think that skill may translate to the bench?
Before I was a middle manager to executive, I thought that process and procedure was for dullards or, hobgoblin little minds. And I thought, why do I need to calendar? Why do I need to, create labels for documentation and things, not just exhibits in court, but through particularly my formative years at United Technologies, I developed a really healthy respect, almost bordering on obsession, for policy and process, but also allowing for the fact that things happen. Someone's child is sick, someone's client is late with a document. I could have said, well, you lose, or I'm not going to address this matter now. I have to get grace, I have to give grace. And so I think that my commercial experience having to manage calendars and matters across not just United States, but global international jurisdictions, and constantly have to reprioritize almost each morning, because the thing that was a fine thing is now a smoldering ember now. You have to respect the fact that we can't control all things, but those things we can control leave space for us to address and be humane about how we approach the work. So I've worked in places where we had challenges making payroll. I know what it's like to run a small business. I believe that my experience gives me a window and a perspective not to believe what I think and to ask more questions than I answer, right? With a view to, if given the option to extend grace or not, always give grace, which is not always the same as an excuse. We all have to be accountable, but capriciousness that it wasn't in by 12:02 because the board was meeting, well, I can make an apology to the board and get it in by 12:05 if it's a better product. So I think my ability to work across functionally, department, be the only voice often of legal to help engineers and finance people get to a common understanding across competing priorities and still deliver. I think that that's a value, because at the end of the day, there are plenty of amazing trial lawyers who are judges. That's not a question. And there are other opportunities for different perspectives to do things and see things differently, to either continue the path we're on or to improve upon it. I mean, diversity is also about the different ways you practice law. And for me, I've gotten more of an appreciation for process and administration as guiding to equitable outcomes, rather than just being a bully whip to hurt people with just because I could.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, I'm not going to ask my question. I've watched you operate under pressure just now. So thank you for joining us today. And congratulations on your nomination.
Thank you.
Next, we have Sean Kehoe of West Hartford. And when you're ready, please raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? You may provide us with your testimony.
Good morning, Chairman Winfield, Chairman Staffstrom, Vice Chairs Flexer, Gadkar, Wilcox, Fazzino, Ranking Members Kissel, Fishbein, and distinguished members of the committee. I am honored to appear before you today. I would like to thank Governor Lamont for nominating me to serve as a judge of the Superior Court. I am also deeply grateful for the love and support of my family and close friends, most especially my wife, my 2 children, Julia and Owen, my parents, my 5 siblings, and the many members of my extended family. By way of background, my siblings and I are proud first-generation Irish Americans. My parents were born and raised in Ireland, and like so many before them, left their family and friends behind to pursue a better life. My mother and father first emigrated to London, England at the age of 16 and 18 years old, respectively. My mother trained to be a midwife, and by 18 years old, she was riding her bike to help mothers deliver their babies around London. My parents would later meet, marry, and decide to emigrate to the United States, as my father was part of that demand for aerospace engineers during the Vietnam War. Eventually settling in Rochester, New York, my parents raised 6 children and are immensely proud that the family now boasts an ICU nurse, a doctor, a neuropsychologist, 2 attorneys, and a Wall Street investment analyst. After graduating from McQuaid Jesuit High School, I attended Providence College and then Quinnipiac University School of Law. For the last 24 years, I have spent the entirety of my career in public service practicing law at the Office of the Attorney General. As a frontline Assistant Attorney General, I was first assigned to the Special Litigation Fraud Department, which investigated whistleblower complaints related to fraud, waste, and abuse in state government. And later, I served for several years in the Child Support Collection Section, where I gained invaluable litigation experience, appearing on behalf of several client agencies in state court, probate court, and federal court. In 2011, I was promoted to Section Chief of the Child Support Collection Section, where I was responsible for supervising all section litigation, including approximately 20 attorneys. I held that position until 2023, when I was appointed by the Attorney General to serve as an Associate Attorney General, Chief of Government Administration Division. And for the last 3 years, I have been responsible for supervising 4 very busy litigation sections, each of which provides legal representation to numerous client state agencies. And lastly, my parents instilled in me core values that have guided me throughout my life and career: the importance of family, faith, a strong work ethic, humility, to celebrate each other's successes and learn from our mistakes, to show respect for others, and most especially to show respect and compassion for those less fortunate. I am truly humbled and honored to be before you today, and I'm answered any questions you may have.
Thank you. Are there questions or comments from members of the committee? Representative Osborne.
Thank you, Mr. Chair. And I think I can say good afternoon now, Attorney Kehoe.
Good
And
afternoon.
congratulations on your nomination.
Thank you so much.
I noticed from your application that you have been with the Office of Attorney General since your admission to the bar.
Right.
And you've had some incredible litigation experience. And I was reading some of those really unique cases that you've had an opportunity to be involved with. And some of them just look fascinating. So clearly, fantastic experience to bring to the bench. One of the questions I have for you is, as somebody who has been employed by the state for your entire career, you don't, oh, I can see you better now. You don't have any experience in private practice. And your client has always been, the 700-pound gorilla.
Yeah.
You've had the advantage of not having to worry about billable hours, not having to answer to clients who are upset, and managing some of the concerns that will befall the attorneys appearing before you as a judge. So what are some ideas, if you have any, and I could put you on the spot, or you could you'll tell me later. But I'd like to invite you, I guess, to consider what are some of the ways that, not having had that experience, I do think it's valuable for people who are on the bench to understand what it is like to stand in the shoes of the attorneys who are appearing before them, to understand the pressures and the concerns, whether it's from a client or from a practice management, perspective, so that you can. There are a lot of questions here about robitis, right?
Correct.
And I think one of the best cures to robitis is understanding what it's like to stand on the other side of that table. So what are some ideas that you have, am I too close to that, to educate yourself on that perspective that you don't have yet? Because I think it would serve you so well, and the litigants and the practitioners before you, to be able to educate yourself on that, to understand in your case management.
Thank you so much. Sure. So certainly over the years, when you're litigating in court, you obviously deal with the private bar quite a bit, and you get to know them, in court, out of court. And so they've, through that experience, they share all the stresses and challenges that they're under. And so I've always tried to be as accommodating as possible. I think it's respectful and I think it's expected, to be honest. So, but then also internally over the years, there's certainly members of the office, colleagues that have come from the private sector, and they share their stories about those same pressures and demands. So once on the bench, I think that I would just continue to do the same thing. I would just constantly engage with the bar and, try to be mindful of that at all times.
Well, I can assure you that that would be a welcome quality in a judge. And thank you again, and congratulations again on your application.
Thank you so much.
Through you, Mr. Chair. Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, I just posed the question, recognizing that you just had an exchange with Representative Osborne, but posed the question that I posed about your system of accountability. If you need me to repeat it, I'm happy to. You probably don't, though.
Thank you, Senator. So I've actually spent a great deal of time thinking about this question. I knew it was going to be a part of today.
Be shocked if you didn't.
So I've actually, I didn't know I was calling that in my own head, the systems of accountability over the years, but I've actually spent a great deal of my career engaging with my colleagues, both peers that are on the same level, superiors, and then once I moved into more of a supervisory and management position, my people underneath me, my subordinate staff, attorneys, paralegals, secretaries. So my goal would be to continue to do that on the bench, not just amongst the fellow judges, but especially the people that are going to be in the courtroom with me on a daily basis, is to affirmatively seek them out after court, maybe even on a daily basis. I hope they won't get tired of me asking, but how am I doing, right? I mean, how did that go today? And be open to any constructive criticism, which sometimes can be hard to hear, but you have to be open to it. And you have to embrace it so you can, do the best job you can do. I really believe in that. And people say mentors. Well, I've always, I think, informally had mentors over the, trajectory of my career. And I do believe in that a great deal. I think it's a significant part of preventing that kind of a problem from happening.
Thank you. And thank you about having thought about the question. I will just say, because this question just now is part of the atmosphere here, I'll just say I don't have a particular answer that I'm looking for from folks. I'm looking for folks having thought about the fact that they wield immense power in the lives of other folks.
Absolutely.
And that a bad day can happen, and that they're thoughtful about what happens. So the fact that you're talking about operating affirmatively matters to me. One of the potential judges once said to me, well, how would you answer the question, right? Because I get to ask the question without having to answer it. And I said, I don't have the perfect answer. But what I do know is that for myself, I have not just talked about empowering folks around me, but made sure that folks knew that the one way that you can upset me is if you don't let me know that something's wrong. And then even recognizing that I've expressed that, asking them, is there a way that, because they may still not feel comfortable, is there a way that we can set up a system that maybe if they don't feel comfortable, they don't have to identify themselves, and trying to work on it. And one of the struggles I have had is the robitis question is extremely easy to answer. I will not have robitis. You can ask my friends and my family, right? But the harder question to answer is, what have you done to think about those times where you're not who you normally are? So I appreciate you for actually giving it thought.
Thank you.
Further comment or question from members of the committee? There are none. Thank you very much for joining us today.
Thank you so much.
Congratulations on your nomination. Nissa Khan of West Hartford. When you are ready, please raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide your statement.
Good afternoon, Judiciary Committee Chairs Winfield and Staffstrom, Vice Chairs Flexer, Gadkar Wilcox, and Fazzino, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. I'm Nissa Khan, and it is an honor to be here. Thank you to Governor Lamont for this nomination and General Counsel Natalie Braswell and her team for their guidance. I would also like to thank my family and husband for their support and my children for inspiring me to be better in all facets of my life. My parents immigrated from Pakistan in the 1980s and settled down in Long Island, where I was born and raised. As a child, I visited Pakistan often, where I observed children forced to beg, work, forgo education, the normalization of crime just to survive, and women with limited opportunities. The government there, in my view, lacked the infrastructure to protect the less fortunate. The wealthy and powerful benefited, while the courts remained figuratively closed to the innocent, the indigent, women, and victims, often leaving them discouraged, silenced, and mistrustful of the courts. I knew early on that laws and liberties ring hollow if there is no protection or implementation by those entrusted with the responsibility to do so impartially. Access to justice and due process are not just legal principles that we're taught to uphold, but they have the power to change lives. As I witnessed individuals close to me bear the consequences of no rule of law, my respect for the role that our judicial system plays deepened, and I chose to pursue a legal career. As an attorney, I have inspired others in my family and community to overcome their mistrust of courts. And knowing my life could have been different had I been living in Pakistan, I've aimed to embrace every professional role with gratitude and purpose. Currently at the Attorney General's office, I represent DCF in child abuse and neglect cases. Our practice, as you can imagine, is voluminous, fast-paced, and emotionally charged. While taxing for some, knowing that I had a part in effectuating our state's policy in protecting children motivated me. I began as a trial attorney, splitting my time between daily court matters, several trials a month, and appeals. Within 2 years, I became the supervising trial attorney, managing and training trial AAGs for one of our busiest courts. Shortly afterwards, I was elevated to supervising our statewide appellate practice. To date, I have overseen over 150 appellate matters, briefed and argued over 30 appeals while supervising countless others, and completed dozens of trials to conclusion. Before the AG's office, I was with the judicial branch, first as a legal research law clerk for the trial court judges, where I was one of 3 out of 40 law clerks assigned to complex litigation. Then as an attorney with the Office of Continuing Education, where I assisted the Office of Chief Court Administrator, the Chief Administrative Judges for Juvenile and Family, and the Judges Education Committee in the development of educational programs and resources for judges. Working with the judges in that role, learning firsthand of the difficult issues they faced, and witnessing their commitment to fairness were inspiring. It was clear to me, from deciding substantive issues to managing their dockets, they played a vital role in ensuring access. Should I be confirmed, I look forward to embracing this new role also with gratitude and purpose, ensuring all individuals have access to justice and being part of a system that I deeply respect. Thank you for your consideration. I welcome any questions.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, I'll just ask you the question that I've repeatedly asked about your system of accountability.
Thank you. So as I'm sure you're aware from my background information, I was at Judicial for quite a period of time, for over 8 years. And while I was there, I was fortunate to develop true mentorship relationships. They didn't happen in a day, they didn't happen in a year, they didn't happen in 2 years. And while I was there, these judges were frank with me. After I left Judicial, the relationship continued and they continued to be frank with me. And some of which who are still there, I know that if I am fortunate to return in this new role, they will be frank with me. In addition to that, I have former colleagues from my time at Judicial, many of whom are with Judge Support Services. And anyone who's worked at Judicial knows that word spreads very quickly. And I hope that if there is any negative feedback or comments about my demeanor or any of how I present myself in court, that my former colleagues would as well feel comfortable talking to me about that. They have been always very supportive of my growth and have provided me with professional opportunities, and I'm sure that they would bring that to my attention. In addition to that, I know that I will have to actively establish a new base in addition to the one that I already have, and that will come with me from setting the stage and being receptive to feedback, and I plan on doing that.
Thank you for that answer. Senator Rahman.
Mr. Chairman, I'm sorry after speaking after you. Attorney Khan, congratulations on your nomination. You are well known, well respected, and well qualified. And Yes, I want to ask you one question. If you are appointed as if you are appointed, are you willing to serve as a judge in any judicial district?
I am.
Great. Well, yeah, like I said, you well qualified. We need more people like you, and I can't wait to vote yes and to become a judge to you. Thank you for applying and willing to, taking the really hard and challenging job. Thank you, Mr. Chairman.
Thank you, Senator. And I don't have a problem with anybody speaking at any point. We want to make sure we get all the information out. Further comment or question from members of the committee? Further comment or question from members of the committee? If not, thank you very much for joining us and congratulations on your nomination. Sean McGinness of Norwalk.
If you could raise your right hand, do you swear or affirm as the case may be, the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat, Attorney McGinnis, and whenever you're ready, we'll take your opening statement.
Chairman Staffstrom and Winfield, Vice Chairs Vizino, Flexer, and Gadkar Wilcox, Ranking Members Fishbein and Kissel, and other distinguished members of the Judiciary Committee. I am grateful for the opportunity to address you today and to answer your forthcoming questions concerning my nomination and qualifications to be a Superior Court judge. I extend my sincere thank you to Governor Lamont for this nomination, as well as Attorney Natalie Broswell and her staff who have been so helpful these past several weeks. I also want to thank and acknowledge my beautiful wife, May, and my daughter, Maria, who I love dearly. By way of personal background, I was born and raised in New Jersey, and I first came to Connecticut in 2002 to attend Quinnipiac University. During college, I fell in love with the state of Connecticut, and I decided to return for law school, once again attending Quinnipiac. After graduating, I was hired as a prosecutor for the state of Connecticut, and it has been an honor to represent the people of this state for nearly 17 years. I've handled thousands of cases over the years, from pre-arrest investigations through post-conviction matters. As a prosecutor, I've always endeavored to consider all positions, look at all sides of a case, and reach fair dispositions. I believe I have earned a reputation with the defense bar for being fair, thorough, and conscientious. Being a prosecutor has also prepared me to make difficult and unpopular decisions if the law and facts support those decisions, something that judges are often called upon to do. I also work as an adjunct professor at Quinnipiac Law, Quinnipiac University, and the University of New Haven, teaching trial advocacy and criminal justice courses. Teaching has made me a better lawyer by requiring me to explain elusive legal principles and repeatedly work with the rules of evidence and procedure. I believe these skills will translate well to being a judge where strong communication skills, knowledge of the law, and patience are paramount. I also enjoy seeing my students succeed. In fact, a former intern and student of mine, Representative Jonathan Jacobson, now sits on this committee. As I look up at him today, asking him for a job, I can't help but think, my, how the tables have turned. The judicial branch is meant to serve the people of Connecticut. As a judge, you are relieved of the duty to advocate for a particular party or position. I have an earnest desire to even-handedly interpret and apply the law. I consider being a judge to be the pinnacle of the legal profession, an honorable profession, and one that requires hard work and empathy. I take my work seriously, but I also have a good sense of humor, and I can laugh at myself. At my core, I try to treat everyone the way I would like to be treated. I recognize that while the case I'm handling may just be another case amongst thousands, it is the most important case for the parties involved. I will be ever mindful that individuals appearing before me could be struggling and intimidated by the court process. If granted the honor of becoming a Superior Court judge, I will be committed to never losing sight of this, treating everyone with respect, and acting with a steady and learned hand. The mission of the judicial branch is to serve the interests of justice and the public by resolving matters brought before it in a fair, timely, efficient, and open manner. I will strive to honor this mission every single day. Thank you.
Thank you. Representative Fishbein, followed by Representative Jacobson.
Thank you, Mr. Chairman. Attorney McGinnis, I have to say that your backup is exemplary. It's the best I've ever seen. I very much appreciate, and I almost want to give you the cover where I wrote extremely impressive. It should be the poster child for anybody who fills out one of these. It is lengthy, concise, informative. It's all the things that we ask for. I have no hesitation at all in supporting your nomination. I think you will be fantastic on the bench, and I do congratulate you on the nomination. So
Thank you.
Thank you, Mr. Chairman.
Representative Jacobson.
Thank you, Mr. Chairman. Good afternoon, Attorney McGinness.
Good afternoon.
Congratulations on your nomination.
Thank you.
You mentioned that you were my intern coordinator. The record should also reflect you were once upon a time my mock trial coach. I see that you continue in your efforts to teach the next generation of lawyers, not just in oral advocacy in a mock trial context, but as a I believe an adjunct professor at Quinnipiac University School of Law. Can you expand upon your views and your motivations in terms of why you emphasize so much of your time in serving the public to also develop the next generation of lawyers in our state?
So I was really blessed when I was in college and law school to have great mentors and people that looked after me. And so I've always kind of viewed it as my responsibility to pay it forward. And if I can do that in any way, whether it's to my alma mater or to an intern, that has always been a source of inspiration for me. And I really enjoy seeing my students do well. I really love when they conquer a legal argument that they've been struggling with. I love, when they do well in their careers. I love writing letters of recommendation for my students. It's what makes me feel good. And so that's the motivation. I feel like I should pay it forward.
You have been involved in a number of cases as trial counsel, high profile to your standard petty larceny. The first case that you thought should be brought to our attention in your application, State v. Andrews. That didn't end in a conviction, right?
No.
That's not something that I would expect to see from a seasoned state's attorney. Why? What is it about the Andrews case that stands out to you that you put it at the number one case for us to consider today?
Well, it was number one by virtue of the last name. I put them in alphabetical order.
That's the attention to detail we're looking for, counsel.
But just to expand on the case, it was a tragic case where the defendant, who was suffering from schizophrenia, stabbed his neighbor 104 times. I actually responded to the scene that day. I was basically assigned the case from the outset, from the first phone call that we received from the Wilton Police Department. And it became very apparent to me that the defendant was suffering from mental health issues. And so after retaining experts for both sides, both experts reached the same conclusion, that he was not guilty by reason of mental disease. And so it was somewhat unusual because a trial is ordinarily adversarial, but in this case, I actually agreed with the conclusion. And the law requires us to have a trial. So I actually called our expert in rebuttal to bolster the defense's theory of the case. And so, just from that standpoint, it was a unique case.
In my ability and opportunity to observe you, the thing that I think stands out about the way you handle your business as an individual, as an attorney, is the way that you would treat pro ses. one of my earlier, if not foundational memories of you is watching you be berated by a pro se defendant. And I don't know if even sitting here today, I could talk to people with the stone face, with the dignity and with the respect that you did on that day and continue to demonstrate every time I saw you engage in that type of conduct and direct discourse with individuals unrepresented whose liberty was at stake. The reason I bring that up is because the quality that I look for most in a judge is arguably their disposition. So my question to you, Attorney McGinness, is can you explain to the committee how you have how you justify or how you handle yourself on a day-to-day basis with pro se litigants as a state's attorney, and how you believe that will translate if given the opportunity to sit on the bench?
So I once heard an expression that people might forget what you said, people might forget what you did, but people never forget how you made them feel. And I recognize that folks that are coming into criminal court that are pro se are often very vulnerable. Many times they have drug addictions or mental health issues or just made a bad decision. I don't need to make their day worse by treating them poorly. And so I've always just tried to conduct myself respectfully, politely. And if they need an attorney, hopefully, steer them towards, obtaining counsel. And I would do the same thing on the bench.
Thank you, Attorney McGinness. Again, congratulations on your nomination. Thank you, Mr. Chairman.
Representative Callahan.
Thank you, Mr. Chairman, and Mr. McGinness, Attorney McGinness, it's good to see you again.
Nice to see you.
I'm sorry I'm not in front of you in person, but I wanted to take the opportunity to reflect on a different angle. The good ranking member mentioned how good your written submission was. I had the privilege and opportunity to work with you when you were a prosecutor in Danbury, and your writing is obviously good. Your interpersonal skills are good, and the way you worked with court staff and tried to get as much information as you could before stepping into the courtroom, and the way you welcomed me into your office and welcomed probation officers, family staff, all court staff, to make sure you got the input needed to make the correct decisions and make the correct advocacy as you're in your role, was exemplary as well. And I'm so glad to see you sitting before us with being nominated to be on the bench, because I think you'd be you're a great candidate, and I look forward to the leadership you'll provide in the future. And whatever courthouse you go to, they'll be fortunate, because you'll work very well with everyone and make things work like clockwork. So it's great to see you, Attorney McGinness, and I wish you the best of luck as this moves forward.
Thank you so much.
Senator Flexer.
Thank you, Mr. Chair. Good afternoon and congratulations.
Thank you.
At the risk of making you regret being so thorough in the materials that you have been complimented for the committee, I happened to notice that one of the cases that you listed in your response to question 16 references attorney who was on the opposite side of the case from you, who's also on the list here today. So you list case number 5 in your materials, the state of Connecticut versus Frederick Mendez, and you outline here, again, a lot of great information about this particular case and why it's one of the 10 that you chose to highlight. I just wondered if you might be able to think if a summary of this case was written by your fellow nominee, Attorney Whalen, how the summary might be different from her perspective than yours.
Well, certainly you'll be able to ask her.
I know, and I feel like I'm giving her a heads up, and you didn't get that benefit, so forgive me.
So Attorney Whalen and I, who I did have a chance to greet this morning, I think have always had a productive professional relationship. We did work in New Haven Part 8 together for approximately 1 year. She actually reminded me today, because I had mentioned to her that she was in one of my cases, that she actually was on maternity leave for a substantial portion of this litigation. And so I don't know what she'll recall from some of the specific motions to dismiss or speedy trial.
Okay, thank you. Now I won't ask her. So thank you very much. Thank you, Mr. Chair.
Further questions? Attorney McGinness, just two quick ones if I could. You have, I just lost my place, sorry. There was well, first of all, I'm finding that I'll join the course complimenting your backup, not because of the thoroughness, because you figured out a way to work Matlock into it. Anybody could do that. But you had noted there was a pending grievance and you thought it might be resolved before this hearing. Can you update us on the status of that?
The dismissal was affirmed, and I do have a copy of that dismissal if you need it.
Okay, if you could maybe just leave a copy with the clerk when you're at the end.
Yes.
And then my last question, probably the most serious one, is just because you're being elevated to the bench, you'll still have time for us to go to MAC basketball games. Is that correct?
Absolutely.
Okay, good. Just making sure. And I've got that under oath. So congratulations on your nomination.
Thank you.
All right. Next up will be Philip Miller. You could raise your right hand for me. I do swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury.
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Thank you. Good afternoon. Judiciary Committee Chairs Winfield and Staffstrom, Vice Chairs Flexer, Gadkar, Wilcox, and Fazino, Ranking Members Kissel and Fishbein, and all the honorable members of the Judiciary Committee. My name is Philip Miller, and it is truly a pleasure to appear before you today. I am honored and humbled to be considered for the position of a Superior Court judge. I want to thank Governor Lamont for nominating me and for the support and guidance of General Counsel Braswell and her staff throughout this process. I want to thank my parents, Carmen and Tony Miller, and my sister Susan for helping me become the person I am today. I'm also very grateful to all my mentors, colleagues, and friends who have helped shape me and taught me. And last but certainly not least, I thank my wonderful wife, Kristen, and my two boys, Jason and Andrew, for all their love and support. I would not be here today without them. I grew up in a small town, Corning, New York, which is where they make the glass. My dad was an attorney. After spending several years in the Air Force JAG, he returned to Corning and for over 40 years was a sole practitioner as well as the town attorney for the town of Corning. Growing up, I could tell how much my father enjoyed the practice of law and helping people. I loved and greatly admired my dad, and I can see now that being around him planted the seeds of me eventually becoming a lawyer. After graduating high school, I was very fortunate to receive a Naval ROTC scholarship. A number of my family members had served in the military, and I was very proud to continue that tradition. Upon graduating from the College of the Holy Cross, I spent 7+ years on active duty in the submarine force. I loved my time on active duty, but I decided to transition to the Naval Reserves, where I served for the next almost 23 years, so I could attend law school and pursue that passion. I graduated from the University of Connecticut School of Law in 2001, and then I clerked for two wonderful jurists that taught me so much about the practice of law, Supreme Court Justice David Borden and District Court Judge Alfred Cavello, and I'm so grateful to both of them. After clerking, I was very fortunate that there were openings in the Office of the Attorney General. I began working there in October 2003, and I've been there ever since. I spent my first 19 years in the Special Litigation Department, and then for the last 4 years, I've been the Section Chief of the Financial and Revenue Services section. Serving in both sections has exposed me to a wide variety of clients in areas of the law. I've had clients from all three branches of government and have handled numerous cases in state and federal court, as well as before administrative bodies and at both the trial and appellate level. The Special Litigation Department would often get assigned unique and/or complex cases that did not have an obvious home, so I had to study and learn a number of different areas of the law. Some of the areas were fairly complicated from either a legal or technical point of view, but I always welcomed and enjoyed those challenges and would work tirelessly until I felt comfortable with the subject matter. My time in both the Navy and at the Attorney General's office has been so rewarding because I've been able to give back to both a country and state that have given so much to me. One of the things I have developed the most appreciation for over the years is the rule of law. I was fortunate to serve as the foreman of a jury on a state criminal trial, and that experience had a profound impact on me. the professionalism of everyone involved in the process, and the seriousness with which my fellow jurors went about their work gave me such faith in our system. I was so impressed by how Judge Vitale conducted that trial and saw from a different perspective how important it is to have judges who are fair, impartial, thoughtful, and thorough. I'm truly honored to appear before you today, and I sincerely appreciate the consideration by this committee of my nomination. If confirmed, I promise to serve with honor, respect, and fairness for others, and to continue to nurture and uphold the rule of law. Thank you again, and I would be happy to answer any questions that you may have.
Thank you. Questions from the committee, Representative Fishbein.
Thank you, Mr. Chairman. Attorney Miller, you obviously have the background and the acumen, which would translate well to the bench, in my opinion. You know, one of the difficulties with individuals that haven't been in the courtroom, judicial selection asks, you know, for references about other lawyers you've been dealing with, judges that you've dealt with in the courtroom. You obviously have that acumen, would be able to meet that bar, whereas others wouldn't. When your name came across my desk, I was like, where have I seen this name before? We had the Oracle case during COVID.
Yes.
It was you and myself, Doug, Kara, and I went back and looked at that, you know, because I know when I file stuff or I'm dealing with counsel in court, I'm always thinking, well, what is the impression that that counsel is going to come away from the exchange? And, you know, last night I went back and looked at our exchanges during that case and your filings during that case. And I have to say, they were always respectful, above board, collegial, and you know, I'm glad to reminisce on that. And I'm fully in support of the transition here today, and congratulations on your nomination.
Thank you very much.
Chairman.
Further questions or comments, Representative Osborne?
Thank you, Mr. Chair, and thank you and congratulations, Attorney Miller, on your nomination.
Thank you.
We have several AAG applications before us today, so I'll cut to the chase and I'll ask you the same question. As somebody who spent his entire career in the Attorney General's office, certainly it's given you great trial experience, and you're obviously qualified from that perspective. How will you inform your experience on the bench? What steps will you take to understand what it is like to be a private practitioner in front of you, and what the stresses and challenges are that they are facing and how that impacts their clients? Thank you very much.
Thank you. I mean, I think I've had some experience in that just because, you know, dealing with private attorneys all the time. And we've had, you know, I've been in a number of cases on trial or negotiations, or, you know, we've had complex cases together. And I think over that time, you know, you sort of hear from them, like how they're doing, what's going on. I've had many times they say, listen, I haven't gotten my client here yet. I think you got a good offer, but I got to go back to my client. So you know, I think I'm very patient with that because I realize that there's a whole different world out there of how they have to deal with their clients, that I don't have to do that. You know, it is sometimes easier to get something through the state. So I think just that experience, I understand the difficulties sometimes that you have to deal with client control and things like that. You know, I would say, for example, I don't think I've ever not given an extension of time, or consented to an extension of time. I mean, I think that's just a courtesy. So I think I'll still always be thinking about that if I'm confirmed as a judge. And I have plenty of friends that are in private practice. So, I mean, just continue to talk to them and about their experience and, you know, just get some feedback, like, how am I doing here? Here's what happened today. Do you think that was a good idea?
Thank you for that answer. And I would just encourage you, you know, the world of private practice is undergoing, you know, a seminal sea change right now because of AI. And private practitioners are, you know, they are lawyers, they are business people, and now they're becoming technologists as well. So I would just encourage you to watch that change as it's happening, and to keep an open mind about the challenges that are being faced by the people who are in front of you. Again, thank you so much for applying, and congratulations on your nomination.
Thank you very much.
Senator Rahman.
Thank you, Mr. Chairman. Attorney Miller, congratulations on your nominations. You are well-qualified candidates, and thank you for willing to serve our state. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? Senator Whitfield.
Yeah, thank you, Mr. Chair. I was out of the room. Did I hear, were you a nuke?
Yes, a submarine officer. Yes.
Oh,
I saw that you're a nuke too, so.
always good to see another one. No further questions. It's a great thing to see.
No system of accountability questions, Mr. Chairman. Well, I guess that does it. Congratulations on your nomination.
Thank you very much.
Leah Pollard. You could raise your right hand. Do you swear or affirm as the case may be that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Good afternoon, Judiciary Committee Chairs Winfield and Safstrom, Vice Chairs Flexer, Gadkar, Wilcox, and Vizino, Ranking Members Kissel and Fishbein, and other distinguished members of the Judiciary Committee. My name is Leah Pollard. It is an honor to be before you today, and I'm humbled and grateful for the opportunity. Thank you to Governor Lamont for nominating me, and thank you to General Counsel Broswell and her team for their assistance and guidance. I would also like to thank my 3 children, Caroline, Will, and Julia, all of whom are here today, and all of my friends, family, and colleagues who have supported and encouraged me and helped me become the person and the lawyer I am today. By way of background, I was born and raised in Waterbury by a single mother who instilled in me a strong work ethic, and I only wish she was here today to witness this. I went to law school because I believe in public service, and I wanted to make a positive difference in people's lives. The majority of my legal career has been in public service, and if I'm fortunate enough to be confirmed, I hope to continue that in the Superior Court. I began my career working for legal aid in Virginia, and now 30 years later have come full circle and am presently practicing as an elder law attorney for legal aid here in Connecticut. I've represented clients in both superior and probate courts in a variety of civil legal matters. Working as a legal aid attorney teaches you to take a holistic approach to your clients, and despite any limitations, addiction issues, or other hardships they may have, to treat them with compassion and respect. To take the time to listen to their problems. This work requires patience and compassion, qualities I believe are vitally important for a judge to possess. I had the privilege of serving as a probate judge in Northeast Connecticut for 17 years. In that role, I presided over hundreds of cases involving various areas of law, ranging from estate matters and conservatorships, determinations of parental rights, and special immigration juvenile status cases. I learned how to effectively control a courtroom and how to manage complex cases. I learned the importance of giving every person who comes into court a chance to be fully heard, and it reinforced my belief that all people deserve to be treated with respect, empathy, and dignity. Thank you for your consideration of my nomination, and I'm happy to answer any questions you may have.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. Congratulations on your nomination. I've never met you before. Reviewing the backup, my takeaway was humility. And I think that's what I see here today, which is, I think, one of the most important attributes. It's very important. You've sat in the role, you've been a probate court judge for many years. I think it's a smooth transition. And I just wanted to congratulate you on the nomination. So,
thank you.
Thank you. Thank you, Mr. Chairman.
Senator Flexer? No, you're good?
Yeah.
Senator Flexer.
Thank you, Mr. Chair. Good afternoon. I just wanted to take this opportunity, Attorney Pollard, to congratulate you. I have served on this committee for 90% of the time. I have been privileged to be a state legislator, and this is the first time I have sat in this committee where there has been a nominee from Windham County. And so I want to, first of all, take a moment to thank Governor Lamont and his team for putting forward your nomination, but really, I think it was probably easy for them. As one of my colleagues has already expressed here today, when looking at your resume, your commitment to public service, and the way that you comport yourself in every part of your life. I think the state of Connecticut is going to be incredibly lucky to have someone sitting on the bench with your character, your expertise, and your commitment. And I'm just grateful that you are willing to step up and serve in this role. I know that people in Northeastern Connecticut were incredibly well served when you were a probate court judge, first in Pomfret, and then when the regional courts were created in the larger regional court. And your expertise really and your commitment really stood out as the lead judge for the Children's Court, which I think many people might say is one of the hardest positions a person in the legal profession can have here in Connecticut. And the grace and humility, again, as was referenced a moment ago, that you brought to that role in particular was just a real it was incredible benefit to the people of Northeastern Connecticut. And I'm hopeful in Northeastern Connecticut, we're going to continue to benefit from your legal mind and your public service commitment in this role. And I also know that your kids are incredibly proud of you here today. And I'm so grateful that they get to be here today to see their mother hopefully reach this great accomplishment. So congratulations to you. And I guess I will just ask you a question. If you could maybe speak to, from your perspective, particularly in the role that you have now, why it's important for there to be people serving on the bench who are from all corners of the state. I know that in recent years, some of the technological updates that have been made by the judicial branch have eased what were concerns perhaps a decade ago, and they're not now. But if you could maybe speak to, why it's important for there to be judges from everywhere, not just the same towns that we often see on these lists in a hearing like this.
Well, first, thank you for your kind words. I appreciate it. I grew up in the Waterbury area, and then I've lived out in Northeast Connecticut for the last 20 some odd years. And it's a small state, and I was shocked at how different the parts of the state are. So I think it brings a different perspective, having lived there so long and knowing that area of the state now, that judges do understand the unique challenges presented by people who live in the Northeast corner.
Thank you. Thank you very much. And congratulations again. Thank you, Mr. Chair.
Further questions or comments? If not, congratulations.
Thank you.
Information. Patrick Ring. You raise your right hand for me. Do swear or affirm as the case may be, the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury? I do. Great. Have a seat whenever you're ready.
Good afternoon, committee chairs Winfield and Staffstrom, vice chairs Flexer, Gadkar, Wilcox, and Fazino, ranking members Kissel and Fishbein, and all the honorable members of the Judiciary Committee. My name is Patrick Ring, and it is truly an honor to appear before you today. I'm very grateful to Governor Lamont for nominating me, and to General Counsel Natalie Braswell, Deputy General Counsel Abhishek Mukund, and all of the staff at the Governor's Office for their guidance and assistance. I want to thank my parents, Jeannie Ring and Thomas Ring, my wonderful wife, Natalie, who is here, and my two sons, Nathaniel and Samuel, whose love and support have been invaluable. I'm a lifelong Connecticut resident with deep family ties on both parents' side to the lower Naugatuck Valley. And I grew up primarily in Windsor, where as a teenager, I had my first job working in the tobacco fields. From a young age, my parents instilled in me the values of education, hard work, respect for others, and service. Their lessons have shaped me into the person I am today. I'm also grateful to my family, friends, and coworkers who have taught and mentored me throughout the years. And as I progressed in my life, I've tried to pay their lessons forward. For the past 16 and a half years, I've worked in the Financial and Revenue Services section at the Attorney General's office. My practice there has focused on cases involving financial consumer protection, securities regulation, insurance, and taxation, and I've become an office resource, particularly in the area of administrative law. I take great satisfaction and pride in the fact that a considerable portion of my work has provided direct and substantial relief to Connecticut and its people in cases that run the gamut in size and scope, from ensuring the return of tenant security deposits, to reforming and recalculating residential mortgage loans, to being part of the leadership team in a multi-state coalition against the credit rating agencies for their role in the 2008 financial crisis. And I've been fortunate enough to argue cases before the Connecticut Superior Court, Appellate Court, Supreme Court, and to be lead counsel on matters in our federal courts and state administrative tribunals. I have tremendous respect for the judiciary and the role it plays. And for 3 years prior to joining the Attorney General's office, I was a law clerk to the Honorable Dominic J. Squattrito at the U.S. District Court in Hartford, where I got to see firsthand not only how the judiciary operates, but also how a judge should act. And as some of you might know, Judge Squattrito was a warm and extraordinary man who treated everyone who appeared before him with respect and compassion without ego. And he always wanted his clerks to be mindful that there were real people behind the cases we worked on. And I've tried to apply his lessons of fairness, courtesy, and empathy to all aspects of my work, whether I'm interacting with opposing counsel, pro se parties, co-workers, or members of the public. I'm truly honored to appear before you, and I sincerely appreciate this committee's consideration of my nomination. If I am confirmed, I promise to serve with honor, integrity, fairness, and respect. And I'm happy to answer any questions you may have.
Thank you. Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Ring, it's great to see you. I'm a Windsor guy too, grew up in Windsor. I'm just wondering, I was Kendrick. What tobacco farm did you work for?
Browns.
Browns, oh, our arch nemesis. And my other question is, are you in Senator McCrory's part of town or my little sliver up in Pequannock?
I'm in Senator McCrory's part of town.
Dang, I still don't have anybody in my part of town. In any event, it's great to see you and congratulations.
Thank you.
Further questions or comments from the committee? Representative Doucette.
Thank you, Mr. Chair. And good to see you, Attorney Ring. Congratulations on your nomination.
Thank you.
We've had an opportunity to cross paths a couple of times in my work up here on the banking committee.
Right.
And I must say I'm a fan of your work. I've always found your work product to be very thorough. You're insightful and most importantly knowledgeable about the issues, many of which are quite complex. And you know, myself in my day job, sort of working in the industry, I'm a transactional attorney. I can appreciate. I spend a limited amount of time in court, and I always say that's probably best for everyone involved. But when I do, I can appreciate a judge who has a knowledge of complex financial transactions and things relating to the regulation of financial services and contracts and so forth. So I think that is a valuable experience. I'm sure, like a lot of the folks we have here today, you'll have to brush up or acquaint yourself with one area of the law or another. But I just want to point out that I think it is valuable to have someone of your experience and expertise, which I think you have shown, again, to me personally, and I think your backup here before us today shows that. I think you'll be a fantastic addition to the bench. I congratulate you. Also, you mentioned Judge Squattrito, who is a legend in the town of Manchester. So that wins points with me as well. I think you'll be a great addition to the bench. And again, congratulations.
He was a legend as a lawyer and as sports as an athlete too. Thank you.
Further questions or comments? Representative Fishman.
Thank you, Mr. Chairman. Congratulations on your nomination.
Thank you.
You know, I do want to highlight your breadth of experience in our courts, federal court, state court, probate court, appellate court, Supreme Court, all of that stuff. And, some people think that, we'll just make them a judge, throw them on the bench. They'll figure it out. But quite frankly, people that go to court are looking for closure. And when you have the quarterback on the bench having to make decisions and doesn't have any experience being in court, you're holding up closure. I had a case a couple months ago, divorce, in the middle of trial, pro se defendant comes in and says, "Oh, filed bankruptcy last night." Judge had no idea what to do with that because they had no experience. Or you get into when the judge doesn't know anything about the rules of evidence getting on the bench, is hearsay or is the best evidence rule take over at some point? Them having to recess to research it and to ask their colleagues is delaying closure. It isn't just throwing somebody on the bench and they'll figure it out. So I do congratulate you on your nomination. You do have experience that I think would obviously translate to the bench, and you are one of the superlative candidates here today. So congratulations on your nomination.
Thank you, Representative Fishbein.
Representative Osborne?
Thank you, Mr. Chair, and congratulations on your nomination. And I'm not going to ask you yet another question that I ask AAGs.
Sure.
But I just wanted to point out something that I really liked about your application is that on the very first page, you said you had a lot of fun litigating appeals. And I'd love to see that because I love the law, right? And I love researching it. I love writing it. I love arguing it. I love all aspects of my job. And the minute we stop having fun with the law, the minute it becomes arduous to us, the minute it becomes a drudgery, that's the time to hang it up, right? And I love the fact that you are still having fun with the law. And I hope that you bring that zeal for it to the bench, because I think that the law is an incredible way to make a living. I think it's an incredible honor. And I'm really glad to see that quality. And I've never seen anybody say that. And it really resonated with me because I have fun with what I do because I love it. So thank you for bringing that to the table, and congratulations on your nomination. It was a comment, not a question. Thank you, Mr. Chair.
I mean, I've always enjoyed, well, I've had some rough arguments in front of the Supreme Court. I think some of them might be in the room today, but that's part of the job. And I really do love brief writing. And as I've moved along in my career, I think I've gotten better and better at it. And you get more confident and okay, I can do this. And I don't know why. I just love doing that part of the job.
And to be clear, there are enough very, very difficult parts about this job.
Right.
Right. So you need to have that zeal and that interest and that love of the law to see you through and boo you through those really hard moments in it. So again, congratulations on your nomination. Through you, Mr. Chair.
Thank you.
Thank you, Representative. Further questions or comments? If not, congrats on your nomination.
Thank you.
For being with us today. All right, John Shaban. Raise your right hand for me. Oh, yeah. All right. You know what? You're okay. Close enough on the side there. Do you swear or affirm the case may be the information provided this committee be the truth, the whole truth, and nothing but the truth? So I hope you got her under penalty of perjury.
I do.
Great. Have a seat whenever you're ready.
Thank you. Thank you. Obviously, I'd like to thank Governor Lamont for his nomination and his expression and confidence in me. I want to especially thank the governor's staff who've been wonderful. You've heard it multiple times today over these last weeks and months with their assistance and guidance. And on the Judiciary Committee, in particular, would like to thank Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, Senator Flexer, Senator Gadkar Wilcox, and Representative Zadano. I'm truly honored. And you hear that word a lot, but it's true. I'm truly honored by this remarkable opportunity that I'm getting, hopefully, to continue to serve the people of Connecticut. I've spent long hours on this committee with many of you, first under Chairman Coleman, and then under Chairman Fox, and then finally under Chairman Tong. And I thank all of you for your service. It was an important committee. It may be the most important committee in the building. And it was an honor to serve on this committee. Other than being a father, I have 3 sons, and now a recent grandfather. I have a new grandson, it's about 5 weeks old. This, if moved forward, this will be the most important job of my career and of my life. I mean, the role of our courts is to serve the people who need to be there, who want to be there, need to be there. It's not for the lawyers. It's not for the judges.
is not for the law school and law students. It's for the people who need and want to be in our courts. Our courts are there to allow people to have their issues vetted and to be the final arbiter of justice if necessary. I hope to be able to bring my 30+ years of private practice and legal career, my 20+ years of public service, and then my life experience to the court. Briefly, you've got my package, but briefly, in my legal career, I've done mostly complex commercial litigation. I have an environmental law degree and done a lot of environmental law and land use. I do a lot of business disputes, large and small business, mom and pop shops to Fortune 500s. And I presently serve as a Superior Court magistrate. I was honored to be appointed to that role last year. And I've been a FINRA arbitrator for the last 15 or so years. My public service, I was a local elected official, as most of you were. I coached youth football for 22 years, and I'm still on that board. I stepped back from holding the whistle last year. I'm on the board and or run of course, I served 3 years in the General Assembly as a state representative. If confirmed, my core mission is going to be to ensure that everybody who appears in my court feels that they've been heard, that they feel that I listened to them, and they feel like I cared. Because I think it was Representative Fishbein, a lot of people are looking for, said it, there's a lot of people there looking for closure, and it could be one of the worst days of their life. I'm there to make it better and to do the right thing. People might not always agree with a judge's decision, might not agree with mine or others, but they have to leave the courthouse feeling like I thought they mattered, they did matter, and that they've been treated fairly. So if confirmed, I promise to be that judge, and I look forward to your questions.
Thank you. Questions from the committee, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Attorney Shaban. I wasn't up here when you served here. You were here for 3 years? Is that
3 terms.
Okay, you did say years, and
Oh, I'm sorry.
I thought you were up
Yeah.
here longer than that.
Yeah.
Your backup doesn't indicate when you were approved by judicial selection. When were you
I
approved?
thought I put it in there. It was 2015.
Okay.
I actually confirmed that yesterday. It's 2015. Yes.
Okay, the answer that you gave was, I submitted my JSC paperwork in 2015. I am uncertain as to the actual date of approval. That's what you told us.
That's right. I had to dig down and find it.
So what did you do to find it?
I found an email setting the appointment to go, or actually getting notice of there's a letter coming that you've been approved.
Letter coming, or there was a letter?
I could not find a copy of the letter, sir, but I did see the email that you've been approved and there's a letter coming.
Okay. And that was sometime in 2015.
That's correct.
Okay. Do you recall the date?
It would have been in the last half of the year, just because I remember when I was up doing the interview was mid-year.
Okay. Is there a reason why you just didn't call JSC and ask them?
Yeah, there's no reason I didn't. Frankly, I thought I'd find the letter. That's really what it was. And
But
then
you
it,
filled out the application knowing that you didn't have the date.
right.
Okay, but you didn't think to call them to ask what their record showed?
In hindsight, that probably would have been a quicker solution than a continuous search that didn't yield anything. So that's, but it was the latter half of 2015.
So I wanted to ask you specifically about the New York situation.
Yep.
So on your backup, you state that you received a non-public admonishment by New York. Do you want to tell us more about that?
Yeah. Well, I was doing my, I think it's biannual actually, credentials review for FINRA. You get on the phone and they go through everything you've done and check out your licenses. And so they update that information for the arbitration panels. And that credentials review yielded to say, you've recently been placed on administrative suspension by the state of New York. I'm like, I did not know that. Then we dug down, realized that I had failed, and I say we, my office, but it's my responsibility to re-register in a timely fashion. And it's a $90 fee and you send in the form and says you completed your CLE credits and whatnot. Connecticut has a similar one, obviously. That I missed the deadline. So I applied for reinstatement nunc pro tunc. We went up to talk to the appellate division, third department, because that's where I was admitted as an out-of-state practitioner in New York. They said, okay, take a few more CLE ethics credits, and you're back in. And that's where it stands.
So for the period of 2021 through 2024, was it? You were suspended from the practice of law in New York?
I don't think it was that long. I think it was about a year. It's what it affected. There was a notice that went out in 21 or 22. And truthfully, with the COVID closures, no one was quite sure what the exact span was, but there was in fact a time for almost a year where I was on administrative suspension. So when I found out about it, I immediately withdrew from all my New York cases, let the judges know. I brought in other counsel. Actually, I appeared in one as pro hoc vice using my Connecticut licensure, and then applied to get reinstated nunc pro tunc, which eventually wound its way through, and I was reinstated.
So you're claiming from 2021 through when you were suspended from
I
practice
believe it
in New
was.
York?
I believe it was late 21 through about 20. No, the notice went out in 21. I believe the suspension came in 22. And then it was arguably till I started the process. Because it's been fixed, it essentially went away, but it was about a little over a year and a half.
Okay. And when were you reinstated?
Early last year.
Okay. Early 2025.
25. Yeah, 2025. I'm sorry.
Okay. So, I mean, I have the reinstatement document.
Right.
And that indicates that you were suspended September of 2022 and reinstated June 13 of 2024. During that period of time, did you file any filings in any New York cases?
Yes, I did. And that was the issue, because arguably it would have been the unauthorized practice of law in New York. And that's why we had to jump on it and get reinstated. And that's why we moved nunc pro tunc.
Nunc pro tunc?
As if it were. It basically relates back in time. So if you want to file a motion nunc pro tunc, it's as if it happened earlier in the time span.
And why did the bar oppose your reinstatement?
No, wasn't the bar? Well, it was the grievance committee, the professional practice. They didn't oppose the reinstatement. They wanted it to be a public admonishment, whereas the third department said no, non-public is fine.
Okay, I'm looking at the decision and the footnote. It says, this is the court. At this time, we declined to weigh in on the substantive issues raised within AGC's opposition papers. So what was their opposition to you being reinstated?
Their opposition was to my motion to be reinstated nunc pro tunc from the get-go, and then have it be a suggested sanction of an admonishment or a letter of advisement. They said, no, we think you can be reinstated, but it should be a public admonishment. So it was more, it wasn't so much about the reinstatement as it was about what the sanction might be.
Okay. Do you have a copy of that? Their opposition?
I probably do. Yes, I'm sure I do somewhere.
Okay. The court goes on to say, however, by the same token, we also decline respondents' request that he be reinstated nunc pro tunc to September 1, 2022. So you were asking the court to retroactively, I guess, in effect, cure the fact that you had filed things with New York court without the license to do so.
While being administratively suspended. That's correct.
Well, when you say administratively, is there some sort of like middle ground? I mean, as far as I know, you're either suspended or you're not.
Well, there's different levels and triggers for it. Some folks get suspended for doing bad things, bad lawyering, taking escrow funds, all the bad things we hear about. This was arguably, a lower flavor of issue because you didn't file your form and you're $90, but it was an important one, and we blew the deadline, and so we had to pay. So I had to pay.
But the sentence is the same, right?
No. So you could get suspended from the practice of law in New York for months or years, and some of it is a public decision, a public admonishment. This was not. So there's levels of sanction that could happen. This was arguably the lowest, other than saying there wasn't a problem, because I admitted there was a problem. Whatever I admitted, that's right. We didn't file the paperwork in time.
Yeah, I'm trying not to dance here. I'm just trying to figure, I mean, the cause of the suspension, I agree, could be, you lied to a judge, right? Bad thing, right?
Right.
Suspended, that's the sentence. You don't file certain paperwork with the system, suspended. Are they not the same?
No, I think my opinion,
legally,
the heavier grade suspension is for malfeasance, is stealing, for lying, for doing something purposefully wrong. So against your oath as a lawyer, and it's against your oath as a person, frankly. Failing to do the proper paperwork is a lower, arguably, and I believe the court bore this out, it's a lesser offense, but an offense nonetheless.
Yeah, I'm just trying to get to the sentence. The effect of both.
Right.
I'm not claiming that you lied or anything like that. I'm just trying to figure out what you were legally able to do or unable to do in this case is the same as if you had lied to a court. Once again, not accusing you of that. I'm just trying to figure out, is there a different level of suspension that I couldn't find in New York?
My understanding is yes. Severely. You could be suspended for practice for 6 months, a year, and you've seen that in Connecticut. I know there's practitioners that's happened in Connecticut because they did something unethical and they were suspended from practicing law or doing anything for 12 months, proactively, not by administrative trigger because you didn't file the paperwork. So there are different levels and flavors.
And what are those? I don't know, maybe I'm being obtuse. Anyway, I'll defer at this point. Thank you, Mr. Chairman.
Thanks.
Questions or comments from the committee? Representative Doucette.
Thank you, Mr. Chair. Congratulations on your nomination. Welcome back to the LOB.
Thank you, sir.
I came across an article and I wanted to give you a chance to comment on it. As I know some of my colleagues up here have seen it as well, which details an arrest from 2019. Again, just wanted to give you an opportunity to comment on that. This is not a question on our questionnaire, which is interesting, and I don't memorize the questionnaire. It asks if you have been convicted, and perhaps there may be a very good reason that is the question. But again, given that this article is out there, and I know, like I said, some of my other colleagues here have seen it as well, I wanted to give you an opportunity to comment on that.
Sure. Yeah, it was a blog post. I think they came out in 2020 after the author found out that there was an event in 2019 that, as described in the blog post, it's substantially correct. I mean, I think you might have overcooked a few things, but my then girlfriend, now fiance, we had an argument. We separated. We got separated purposefully when she thought I was stranding her. She called the local PD saying, my boyfriend took the keys and is not letting me in the house. I called Uber. By the time that the locals came, they came in, gave each of us a ticket, drove her home as a courtesy to both of us, and then we just let it play out from there. And so, we appeared in court. The DA said, all right, let's move this through as appropriately as we should. We agreed to do, slight. It wasn't a diversionary program per se, but you jump into that. You say, give us 3-4 hours of meetings or whatever you choose to do. Report back. Everybody's still playing nice, and we'll drop the charges and everything goes away. And that's what happened. But the argument did happen, and the summons did happen. So that's, I'm not going to deny that.
And the charges were dismissed after the completion of this.
They were never asserted. I was never charged with anything, neither was she. There were no charges asserted by anybody. And that's kind of what makes this a little different, that sometimes you get those diversionary programs where there's a charge and then it's dismissed. My understanding, and I just went through a pretty rigorous background check, is there were no charges. And you know, while we're on the topic, that experience, however, it's funny because while that experience was unfortunate, and it provided me with a unique opportunity that I think is important for this role that I'm trying to acquire now. And you know, as a judge, you know, if you're a litigator, you're on the one side of the bench and you're in court all the time and you're doing litigator stuff, you know. And if you, as a magistrate, you're sitting on the bench doing smaller cases, small claims and whatnot. But rarely do you get to see the effect of some of the programs and legislation that we pass in this building and the building across the street, such as, you know, these diversionary type programs or meetings or counseling or whatnot. And even though I had a brief glimpse at a lot of people who were good people who had gotten caught in a bad situation. And being able to see that firsthand, not just read about it or sit on a committee and hear about it, to actually be able to see it, gave me a sense of empathy and sympathy, I think, that'll help me in this role if affirmed or if confirmed. Because it was a learning experience. It's one of those things that, you know, it was an unfortunate experience. I'm glad it was put behind us quickly, but it actually gave an opportunity to learn some things about myself and about our system.
No, I appreciate that. And I agree, actually, too. I've been on this committee for quite some time. And if you were here earlier, you heard I'm a transactional attorney, don't visit court a lot. So I learn a lot as well on criminal matters. And I sit back and listen and try to absorb and defer to my colleagues and the professionals who work in the field as to the, you know, the finer details of that. So I guess that brings up another question. So you say, and again, I'm not being a practitioner, not being an expert, you say it was a ticket. And that there were no charges.
No, no charges were asserted. We each got a summons. You get summoned to court to answer these potential charges. And the DA says, well, this DA said, all right, I'm not going to press this forward at all, pending you guys doing X and such, which we did, a few hours of classes or whatnot. Came back, everyone was still on board with the program. We were obviously still together. And then everything was dropped. So it wasn't like a case that there was a charge and it was dismissed. It just actually evaporated in that early stage.
Okay. And so it was your testimony here, it was one very bad night and nothing else ever occurred like that.
No. Yeah, absolutely. I mean, that's, you know, nobody's perfect. No couple is perfect. No relationship is perfect. But I'm happy to say that we're still together and we're moving forward.
Yep. I appreciate that. And again, I just wanted to give you an opportunity to comment. I think it's only fair, again, that this information is there.
No, it's fair. It's fair game. Absolutely.
And so I think it's only fair to you to give you a chance to respond. I appreciate it.
I appreciate that.
Thank you. Thank you, Mr.
Thank you,
Chair.
Representative.
Who's next? Senator Winfield.
Thank you, Mr. Chair. I'm going to go right back to that situation. So you described it as an event and talked about being caught in a bad situation and a learning experience. I'm going to start with what was the lesson from that?
To evaluate, there's a lot of lessons actually. I mean, the exact lesson itself from the relationship point of view is maybe to have some better reentry planning and some situational awareness, just to diffuse things before things get out of hand. That's a life lesson that you learn all your life. But in terms of, you know, the lesson for this potential role is what I was saying is getting a glimpse at, you know, these diversionary meetings and whatnot to see how good people sometimes get rolled up in bad situations, and to have a firsthand awareness of that, I think is helpful, if not crucial, to being a potential judge.
Yeah, and I don't know the situation. I am aware there was a situation. I chose not to delve too deep into it. Was this a situation that involved alcohol?
No.
So I'm a little confused about the ticket charge thing. So I'm going to ask you to walk me through that.
Mhm.
So the incident occurs and there's nothing going on when when law enforcement arrives, but you still get a ticket. Help me understand what happened here.
Yeah, the local PD
Yeah.
came. The other party's outside my house. They're standing with stuff in the driveway, trying to figure out how to get home. I'm inside the house.
Wait, just slow down. The other party being your current fiance?
Yes.
Okay.
Yes. Outside the house, the police are, what's going on? I was like, well, he took my keys and locked me out of the house. And they came in, I talked to them. I said, well, I didn't think she should drive. I was the designated driver that night. So I said, you know, either stay here or it was late, so I'll get you an Uber. So no, I either give him, there was a disagreement about how the path should proceed. And they, so the local PD said, oh, you know what, we're going to drive you home.
To your fiance?
No, it was at my house. She went to her house.
Right, but they're going to drive her home.
Yeah, they drove her home. Yeah.
Because of
because rather than call it
impairment.
Well, no, they just did it as more as a favor. That's kind of the Reading Police Department.
Okay. So I don't love cutting folks off, but I'm trying to follow. I asked you, was there alcohol involved? You said no.
I took that to mean me.
Okay.
And I can't speak for others, but what I will tell you is what that article says is it was my thought at the time that she shouldn't drive. And so either I was going to drive her when I was too tired, I was very tired, I was late, or I got an Uber, and I had called an Uber, and the PD said, cancel the Uber, we'll take her home.
Okay. And so the police arrive and there's still commotion going on because she still wants the keys, I'm assuming.
I don't know about commotion, but yeah, there was still something to discuss. Obviously, she was outside.
I mean, they gave you a ticket. They didn't give you a ticket because she was standing outside.
No, they gave it because there was obviously an argument. They gave us each a summons.
Yeah. So then you make your way to court.
Right.
And you described this as not a diversionary program. Was it AR? What was it?
Well, it's what we offered. Said, so how about we, put it on ice. And I'll talk about my path. It was like you take, I think it was 4 hours, 3 hours of meetings, situational awareness, that kind of thing, which I think are also part of either a diversionary program or AR system. I mean, those meetings serve a bunch of functions, as I recall, and as they certify you took a few hours, everybody comes back to court and still happy with each other, and we'll drop everything.
Well, that's how I understand these things working. But the way you described it was different. The way you described it sounds like there was nothing to drop.
Well,
right. The way
they didn't charge anything. Yeah, they did not proceed with charge. I was not charged
because you completed the program or you completed whatever the agreement
4
was.
hours or whatever it was.
Right. But should you not have completed it,
they could have proceeded.
The charge. So there were. This is where I guess my confusion is, because the way, like, if I were just listening to this, it would sound to me like there were no charges hanging over you at any point.
Okay. Yeah. No, I guess that's a fair question, because maybe that's the way it sounds like. When I went to the 3-4 hours of classes, there were charges on hold. They hadn't been. We had not been charged, so we're gonna put everything on ice. You guys do as agreed, and then we'll drop everything. And I'm not trying to make semantics out of it. Maybe it's a distinction without a difference. I'm not sure that's true, but for the last 20 years or something, every year I've got to go through a background check as a coach, and then as a magistrate, and now as a judge. There are no charges, no arrests, nothing on my record. And by the virtue of this incident, it was because we came to the agreement and did the few hours of classes that I had to do, or I agreed to do. Yeah.
Yeah, and I'm aware of how these programs work and what it means for your record, but I'm struggling a little bit because. And I recognize you may not mean this. It feels like your answer to the question isn't completely straightforward, and that may just be my interpretation of it.
Mm-hmm.
But you're seeking to be a judge in our system. We're talking about your experience with the system and what happened,
right? And
it feels as if there's a need to dig to get clarity on what happened. And it feels to me, if you're sitting in front of us under oath, it should be extremely clear in your answers about what happened in this situation.
Well, I've tried to be clear, Senator, and I apologize if you think I haven't been. I've tried to be as clear as I can, and I've told you everything that happened, that what I witnessed, what I experienced, and what happened. I mean, I said the blog post was mostly right. I mean,
I'm less concerned with the
Yeah.
blog post than with engaging you. I don't
That's
take any, listen.
right.
Yeah, right. I don't take anything necessarily to mean more than someone wrote a blog post. We have the opportunity to speak with you to get clarity. And that's why speaking with you and getting clarity means so much to me. Let me just jump to my other question since I'm talking to you and it kind of relates to this. So what is your system of accountability?
Well, I, as others anticipated your question or a question like that, I've always tried to self-analyze and most of the things I do, kind of go back, review my work, review my effort, talk to my peers, talk to my the people I coach, the parents whose kids I coached, talk to my associates, talk to whomever I've worked with or for, and say, how'd we do? Could we have done better? How do we do better? And that's been sort of a personal practice, because that's one of the few ways you do get better, because nobody's perfect and you're always going to get better as you go along and learn. So I try and take that as use that procedure as an example. And that's, like I say, it's not just in law, but it's also in life. It was like with the coaches and the parents. I think that's an important thing. I coached youth football for 20 something years. I was happy to be awarded the Positive Coaching Alliance Award 6, 7, 8 years ago, and a few other sportsmanship awards. And I took pride in that, because that meant that we were, not just I, our whole staff, were giving the right lessons to the kids, to the young men and women. We had women on the team, and we also did the cheerleading. But you also can say, what can we do better? And we asked the parents, we asked the kids, what'd you like? What didn't you like? Did you have fun? Are you coming back? It's fun now, being of my age now, and I'm walking through an airport and I hear, hey coach, and I turn around and I see the 6'4" version of the 5 kid that I used to coach. Oh my goodness. And it's heartwarming to have grown men still call you coach and still thank you for that effort, because it meant something to them, and it obviously meant something to me. So you always go back and check with who you're working with, who you're working for, who you're coaching for. And I hope to continue to do that. I mean, I know there's some paradigms set up within the judicial branch to do that already with reviews and whatnot, but I think a more fastidious review personally it would help everybody, especially me.
And I appreciate that. My concern is that there've been, at this point, I've been here long enough to say, plenty of folks who have come before us who have felt like there are systems in place, external to systems created by themselves, that would be helpful to them, some of whom are no longer on the bench. And I don't want to be involved in putting people on the bench who should have been more thoughtful, should have been more proactive, who are not. And so I guess my question to you as a follow-up to the prior question is, talking to folks who you coach and all of the folks you described, that's great. What do you do to make sure that when situations are not the type of situation that's easy to deal with, giving feedback, what have you done to make sure that folks feel safe, comfortable, particularly when they're in a subordinate role to you?
Yeah, that's a great question, especially for a potential judge. You have to make people feel that you care and you're listening, and that it's not a threatening situation, and you're trying to advance the ball appropriately. And I've been lucky enough to have some experience in this role, because now I'm a magistrate judge, but before I got elected to the General Assembly, I was also a fact finder arbitrator, which was sort of a similar role that we had back then. And so, I conducted hearings, and we had clients, or not clients, we had, litigants come in, and most of them are pro se. I mean, in some of the former roles we did have attorneys, but most of them are pro se. And the hope and the goal, even now, has to be to make them feel welcome and make them feel empowered with the ability to kind of do what they have to do. Because whether they want to be there or they need to be there for whatever reason, they shouldn't feel like they're getting thrown to the wolves. whether it as a judge and as a judge staff and working with the judicial staff, we all have to do a good job making sure that people show up there and feel like they're getting a day in court and they're getting a fair shake.
Well, thank you for that. Thank you, Mr. Chair.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Shaban, it is great to see you. I am one of the individuals here that served with you during your 3 terms in the legislature, and you were a pleasure to work with as a colleague. Back in a past life, I was in private practice. I had criminal practice, and also for a number of years, I had a contract as a special public defender. So I just want to try to help clarify the situation that happened. First of all, with you and your girlfriend at the time, now your fiance, what town did that take place in?
Town of Reading.
Okay, so Connecticut,
Yep.
where we don't have district attorneys, we have state's attorneys, prosecutors. So at that time, when the police arrived, they did not arrest either of you, but they charged you and gave you a summons. What was the charge on the summons?
I believe it was disorderly conduct. For a while, I
Okay.
thought it was disturbing. It was disorderly conduct.
Disorderly conduct.
Right,
And
right.
did your significant other have a similar charge?
Yes.
Okay, so you both went in on the court-appointed date under those charges. Now, a couple things can happen, and I've seen all of these things happen. There's a formal process in Connecticut where you could have applied for accelerated rehabilitation. You're not really contesting what took place. You're agreeing to go and take a diversionary program, and then the charges essentially get wiped away. But I've seen on occasions state's attorneys sit down and it's without the formal application process say, if you folks go and do X, Y, Z, then come back with evidence that you have fulfilled those obligations and we'll drop the charges. It has the same effect as an accelerated rehabilitation. It actually is more beneficial if you can get a state's attorney to approach it that way, because you actually save your ability to use an accelerated rehabilitation program application down the road. Because
Correct,
once you do some of these things, that's sort of like your bite at that programmatic apple. And we have a lot of programs. So maybe that would not have availed, but substance abuse could avail or something else like that. So from what you're saying, what I'm hearing is that you did not file the papers for an accelerated rehabilitation, but it was merely after a conversation with the state's attorney, he or she suggested the programmatic methodology and you fulfilled that. And then you subsequently came back to court with an indicia that you fulfilled those terms. And they said, that's all right, Attorney Shaban, those charges are dropped. You're free to go.
That's you said it, or you described it to a T. The conversation was in the hall. There was no paperwork. It was reported this is the way we're going to go, and back in X months, and that's what happened.
Okay. And the fact that you are now engaged to this woman is an indication that also there was progress made in that relationship situation and that you're doing much better now than back then.
Well, I hope so.
Well, the fact that she's here,
Right.
fact that she's here in the meeting room with us all is a good indication that she certainly supports this. So I'm glad I helped you clarify that.
Thank you, sir.
And sometimes when people get nervous, they talk quickly and it makes it seem like they're hiding something. And I hate to say it, but it was sounding like you were getting nervous and you were talking quickly, and it was coming across as like obfuscation, where I know you did not mean that, having served with you for 6 years. So relax, take a deep breath. We all have crazy things that happen, but it's how we respond to those things that really define us. And I just want to say that clarifies any questions I had regarding that matter. I think you're extremely well qualified, and I think you'll make an excellent judge, and I wish you the very best. Thank you, Mr. Chair.
I appreciate that, Senator. And if I was speaking quickly, I apologize. There's a little Brooklyn, New York in me still that kind of gets at it.
Yeah, it comes through. Just remember it when you're a judge.
Senator Flexer.
Thank you, Mr. Chair. Good afternoon. Nice to see you again.
I see you, Senator.
I want to pick up on this general line of questioning that we've been having. Can you tell me about your town of Reading? How long have you lived there? How many people live there? And tell me what the police force is like. What's the structure of it?
The town has roughly 6,800 to 7,000 people, and it's been that way for decades. When I first moved there 24 years ago, we had just installed a police department. Up until then, it was state police cruising through. We had just only recently before that. So we've had a police department for roughly 25 years. Their officers, the number of officers range from 4 full-time to 7, 8 full-time, with a lot of part-timers and animal control officer and whatnot. We have a new police chief as of recently. As actually a friend of mine came out of Fairfield, very qualified police chief. I was happy to see him get the job. And we have some auxiliary police, and we have volunteer firemen. We don't have we have volunteer EMTs. It's a small town.
Thank you. And I know that before you were elected to the legislature, you had a few roles in local government. I don't think they were anyway connected to conversations about law enforcement in your community, but did you have any role in advocating for the creation of that police department? Did you ever speak out in any, I suspect that Reading is a place like the small towns I represent that has town meetings. Did you ever advocate for the police department, either its creation or its operations in any way?
Well, it had been created by the time I just moved to town. But when I was in local office, I was a chairman of zoning for a bunch of years. The vice chairman of zoning. I was a chairman of the Water Pollution Commission for a number of years. I was on a bunch of other boards and commissions. Once I got elected to the State House, I would speak with my three towns, Reading, Easton, and Weston. We would speak to all the police chiefs, have meetings, and tell what's good, what's bad, what do you need, what's going on that I should know about. So I had those meetings. There wasn't necessarily I think my three towns, especially the town I'm living in now, but my 3 towns of Reading, Easton, and Weston, I think that the community had a relatively good relationship with their police force. I mean, it's not always perfect, and you always have 1 or 2 flyers in a department that get weeded out. But I think generally we've had a pretty good effort at it.
Okay. A minute ago, Senator Kissel was very kind to you in trying to get you to explain this incident that's been in question today and the court procedures that followed after. I wonder if you could think about when the police show up for this particular incident to you, John Shaban, a known political figure in your community. Have you spent any time reflecting on that experience that you had that day and the other people involved had that day, and what that experience is like in a different community with a different person who is not a known political figure and an attorney?
And that's an excellent question, Senator, and it kind of feeds into the reflection that I offered. Some of the other people I saw sitting in the room with meetings were similar as you described, folks who may or may not have been in political office or whatever, and they were good people that got caught up in a bad situation. And our ability as a society and as a court system and as a judicial system to give otherwise good people an opportunity to get out of a bad situation it was a great experience to see firsthand, because it was a great experience to see firsthand. On the initial confrontation part, which is also part of your question. It's I know this legislature, when I was here and after I was here, we've all spent, and you've all spent a fair amount of time trying to help manage or help mitigate or soften that first contact situation where possible. And I think that's a good thing, because citizens should not be afraid of their police department. And the police department is not there to play gotcha on their citizens. They're there to help, just like we're here to help, just like everybody who goes into public service should be going into it because they want to help. And I think the more we do to promote that approach to public service, whatever your role is, I think the better we'll all be.
Thanks. Thank you for that response. But I guess I'm also asking you to really think about what that police response to a similar call in a different community with a different set of people looks like And can you think about how those same circumstances might end up with people in the back of a police car if you're not a known political figure or an attorney?
It could, and it's an important question to ask, because that's part of the perspective that everybody needs to do the work that you've continued to do and this committee continues to do. Yes, I have thought about that, both when I was on this committee and now seeking this current position. That's right. And the more we can promote positive police relationships, with whether you're going to a call or you're going to a parade, people shouldn't be scared of their police department, and the police department shouldn't be there to scare people. Sometimes you have to. I mean, there's bad things happen, and they have to be aggressive. But it's an important. I mean, your question is probably more important than the answer, because just by asking the question, that's where you get the reflection of, all right, how can we do things better?
Thank you. I'm trying to think of the proper way to phrase my next question. Have you ever had any other interactions with the police department in your local community that, again, trying to reflect on the way different people interface with law enforcement than the way that you or myself, frankly, with the position that I have, get to interact with law enforcement as a former legislator, as you as an attorney? Have you ever had any interactions with law enforcement in your community where something was perhaps brushed aside because they knew you? Maybe those officers, maybe those kids that you're talking about who you once coached are now members of that police department. Has there ever been any incident like that in your community with an interaction with you specifically?
I don't. It's a good question. I don't think so. I mean, I suspect. Well, there's one where my oldest son, who's sitting over here, might have gotten out of it. They called it, quick caveat. I got a call. I was up on the floor of the House. We were in a session. I got a call from the chief of police and say, good news and bad news. The good news is your son is, witty. The bad news is, we had to give him a ticket. The better news is he tried to convince the officer that no, they sell beer in an 11-pack. So we're like, all right, no, they don't sell beer in an 11-pack. And B, you're not old enough. So they ran him up. They wrote him up. But I don't know that he got any softer of a reaction than might have otherwise. I don't know. But again, the question is an important one. He did have to go to he had to pay it. He had to show up at court, actually up in Danbury. And it was, the funny thing is, the other Shaban, it was Judge Shaban. There's actually another Judge Shaban. So there's Magistrate Judge Shaban now and Superior Court Judge Shaban. And he saw the same name on the board. He thought I set something up. I'm like, I know I didn't. But it's a good question. The way police respond to people, to their community, is extremely important. And whether you're an elected official or just a local retired fisherman, or just a retired person, you like to be able. I like to think that the police have a responsibility and obligation to treat everybody with kindness first. And I think that works the best.
I genuinely appreciate that response to the question. But do you recognize that experience that your son had, and I really am grateful that you shared it. It was brave of you to share that, and I hope that he will still continue to have meals with you after that. But do you recognize that there are going to, if you are confirmed, and depending on the assignment that you're given,
right,
that there are going to be young people in front of you who are not the son of John Shaban, who did the exact same thing, and are going to be in a whole lot of trouble?
Yes, and I do recognize that, and I'm going to take that into the mix, because having raised 3 boys and now a grandson, having coached young men and women, having still been a mentor to a lot of them, I'm still helping out with the 6th and 7th grade team, and everybody else is 30. It's a big span of young men and women. I'm going to, whoever appears before me, I'm going to treat the same way as I would treat my kids and those young men and women that I coached. Everyone deserves a soft and friendly approach by the police. Everyone deserves a soft and welcoming approach by a court. Everybody. And I vow to be that judge.
You, I think, clarified with Senator Kissel that you took an accelerated rehabilitation course that you said was about 4 hours. Is that
I
correct?
think that's right. Yeah. Yeah.
Can you tell me what you learned during those 4 hours?
Yeah, it was more about situational awareness, and it was like everything else. You go in a good attitude or a bad. I went in, decided to go in with a good attitude. Let me see what I can learn here. It's about situational awareness, how to manage other people, how to manage yourself around other people, how to manage other people around yourself. Situational awareness, just to know when it's time to leave, know when it's time to diffuse things, recognize the signs that someone's about to drop a lit match on a fire potentially, for all people. I mean, and then recognize that their big expression, it's an overused expression these days, is, they put tools in the toolkit, but it actually was a useful expression or euphemism. It's just to give you a couple of alternative thoughts. It's like, hey, rather than confront some Yahoo in a bar, why not? This is the examples we heard. Why don't you just leave? Just get out. Just walk away. Don't get involved. And it's good advice. It's good advice for everybody.
I really appreciate that response as well. But as you were learning that, what were your answers to those questions about the situation that got you in that course to begin with?
Well, they did really ask about how you got there.
Excuse me, I don't mean that they had an interaction with you, but as you were processing what you were learning, what did you reflect back on in your mind and say, oh, this was the match that I shouldn't have thrown, to use your metaphor?
Right. Whatever the appropriate metaphor is, the thing you learn is situational awareness, how to diffuse. And this is a life skill. You learn this all your life. How to diffuse conflict or avoid conflict, and not contribute to trouble before it starts. And that's it. That's in everything. That's whether you're working with other lawyers. That's whether you're in a private relationship. That's whether you're working with your neighbors in some project. There's personalities. I think one of the things they called it the iceberg theory. They said everybody's an iceberg because there's only 1/3 above the surface that you can see, and the other 2/3 are beneath the surface. So treat everyone like an iceberg, because you don't know what that other 2/3 is. And if you're starting to feel angst about whatever it is, whether it's professional, personal, neighbors, just recognize that you don't understand the full picture, and vice versa, and take steps to avoid hitting the iceberg, so to speak.
And I appreciate that. But I'm asking very specifically, when you reflect back, and you probably wouldn't still be up here talking if it weren't for this particular incident.
Right.
But when you reflect back on that particular incident, based on what you've learned both in that course and in the time, just the general time that has elapsed since then, what specifically would you have done differently that would have prevented the police from being there and a disorderly conduct charge, or whatever the proper term is, from being, what would you have done differently that you know now that you didn't know when these actions took place?
Better communication. What did everybody expect, when and where, and what was going to happen? That would have put the fire out before it ever started.
Okay. Who ran the accelerated rehabilitation course? Do you remember what organization it was?
I think it was ARC.
ARC. Okay.
I believe it was ARC.
Okay. And was the other party who was a part of this incident in the course with you? Did you take it together, or did they take it someplace else?
I took it alone.
You took it alone. Okay. And did they take the same
No,
course?
there was a different path
Okay.
for them. I'm not 100% sure what that was, but there was a different path.
Okay. And when you had the conversation with the state's attorney that you described to Senator Kissel that led you to taking this AR course, was that someone that you knew already, that you had an existing relationship with, or just tell me more about how that came to pass?
No, that's a fair question. I actually use an attorney, a friend of mine, because I don't know criminal. I don't really practice in criminal law. So I had an attorney with me, and I did not know the state's attorney.
Okay. But they described this to you as do this now, and then the next ordinary steps would not happen. Can you just, again, detail exactly what that conversation was and what was presented to you as options?
Yeah, it's similar to how Senator Kissel described it, and I appreciate the succinct because of your experience. It was it was an informal conversation first. Say, hey, let's all get in a room and talk about paths forward here without.
Can I interrupt you for one
Sure.
second? When you say all get in a room, who are the all?
Oh, it was we did separately. The two parties of the thing, it was separately. Let's get in a room and say, yeah, my attorney had an idea, the same, similar to what the state's attorney was willing to suggest. And they said, yeah, this is a perfect opportunity to kind of shortcut this, do it in a somewhat informal basis. Don't have to go through the paperwork of the program and you're in, you're up, you charge, you're not charged. Just, I'm just going to put this on ice, do what you promise you're going to do, and it'll all go away if you do. And it was like it basically, as the senator described, it happened before anything happened.
What does it'll all go away mean?
No charges are filed.
But that also means it's not on any record that the judicial branch holds?
I don't know. I don't think so. My understanding is that I'm not 100% sure, frankly.
Okay.
I don't think so, though. I'm not sure.
So to your knowledge, the background check that was conducted before you were presented to us in this committee today, it wasn't on there?
I believe that's correct. Nor was it on the other 20 that I did for youth football or the one for magistrate or the one for FINRA. So to go back to your previous question, it must go away because it was never on any of those background checks.
Whereas if you hadn't been given the opportunity by the state's attorney to take it at the point in time that you did take it, and you had gone through a longer procedure in the court, would AR have appeared on your record after that?
And I'm actually drawing on my recollection from this committee.
And it's sort of a trick question. I think the answer is no, but
yeah, I'm not 100% sure. But I think the senator may be right. Yeah. I mean, my understanding of it is you do accelerate. There is some record of it for the reasons that we discussed, because if you jump through the formal hoops and file the paperwork, you typically get, one bite at the apple, so to speak. That's not what happened here.
okay. Was there a record that you were in this program for any period of time, or you just you never went back to the state's attorney again? You took the suggestion, you figured out whatever the process was to enroll in the course. What was the span of time between that meeting in the attorney's office and actually being in the course?
Weeks, a couple of weeks.
And
yeah, you had to get enrolled and you get on a calendar for 4 visits or 3 visits, or I can't remember what it was.
And then you received a communication from the court that your case was.
I believe my attorney, I don't know if he had to go back, but I believe he did go back to speak because he was there for other stuff. He was a criminal attorney. He said, hey, by the way, this has been completed. Okay.
Okay. I have a few other questions, but I don't want to ask them in a public setting for the privacy of the other person who was involved in that. So I may save that for a different conversation. But just generally, can you tell me, and you did a little bit in your response to my questions about the course, how have you changed?
Well, I think similar to what we were talking about before, it gives you a little more reflection. And the other way I've changed is to actually get a view of what courses and programs like this, how they help people, how they help good people get out of bad situations, and that how we as former legislators or potential judges and jurists you have to promote and use these structures and these programs that we put in place to help good people get out of bad situations, and to be sympathetic to the fact that good people get in bad situations. I'm pleased that at least while I was here, we did some decent work on that front. I know this committee's continued on that work because it's important. It's important. One strike and you're out is not who we are as a people. I'm not even sure 3 strikes and you're out is, but you've got to be given a shot at and our structure. I'm happy to say provides that. So I was happy to see that, and that changed me. It really did.
Thank you. I appreciate that answer. I would say that I hope there's a lot of good people who don't find themselves in the same circumstances. So,
And I understand your point.
yeah.
And it's a valid point. And it's something to be aware of, especially as a judge. Make sure that everyone's treated fairly. Everybody.
Thank you. Thank you, Mr. Chair.
Representative Osborne.
Thank you, Mr. Chair, and thank you, Attorney Shaban, for being here. And same topic. But I deal with people in these situations all the time. I practice oftentimes high conflict family law. And there are a lot of people who end up with a disorderly charge. Maybe both people are ending up with the disorderly charges. And it changes people, right? The enormity of going through that experience, people who never thought they would be in that experience in their lives. And I'm wondering, you come from a world, I'm getting too close, I'm sorry. You come from a world of commercial litigation, and you would have had, frankly, no other opportunity to ever get to know anything about the criminal justice system or anything about ADR. And there's a chance that, if you're confirmed, if you're successful in this process, you may end up sitting on the criminal bench. And I'm wondering, and you've already answered this to some extent, but I look at that and I say, this must have changed your perspective. You've never had any involvement with criminal law. It must have changed your perspective in the future as litigants would come before you. That whole innocent until proven guilty thing has got to take on a whole new flavor for people, right? And fortunately for you, your experience was short-lived. It is for a lot of people who end up with a disorderly in the middle of a domestic. It is very short-lived for many people. It's not that unusual. But if you could expand a little bit more about specifically on that innocent until proven guilty part, especially in the context of domestics. I'm not asking you to opine on domestics because you haven't been involved in that side of it, but how will it have changed your perspective as people come before you who might have charges that you might not even have considered before because you had no life experience to bring to the table?
Excellent question. It's, every life experience I have changes you somehow. And if you're like I am, and I believe most good people are, you try and learn from it. You try and extract from it, and you try and drive a life path forward from it. If I'm confronted with that situation as a judge, and if asked to serve on the criminal bench, I'll throw myself into it. A friend and colleague now who sits on the criminal bench called me yesterday to wish me luck and said, if you're lucky enough to go to judge school, she was going to give me a very hard time. So I said, oh, thanks for that. You learn from this stuff, and the innocent till proven guilty is one of the core tenets of our society. I mean, from habeas corpus on down, from before the country was the country, that was one of the tenets that sort of made us a country. Is like, you're not going to, the government just can't come slap cuffs on people and drag them away because of what the government says they did. No, there's got to be a whole lot more that has to happen. And you hear it, you hear it at law school a lot, and you hear it in law seminars and whatnot. The system is you'd rather have a guilty person go free than an innocent person get locked up. And there's truth. That's the truth. That's the path that we have. And it's actually been the model for the world, I think, for the last 200-300 years. And, we're not perfect at it. We're still expounding on it. We're still improving it. But yeah, it's an important thing. And I had, I mean, my little flash of it, again, was to acknowledge that there's a whole room of people here who are good people. There was, some fellows that needed interpreters. There was, one guy was a retired fella. There was a lady who, just moved into town. It was, they're good people. And because of the way we do our business here and in the court system, those good people got an opportunity to continue to be good people.
Thank you for that response. And I just want to acknowledge, this is embarrassing stuff to talk about, right? For most people, this is embarrassing. This is hard. It feels awkward. You've answered some very personal questions, and trying to be very deferential and protective of the other person involved. It's a hard situation to be put in. So thank you for your candor here today. And it's not embarrassing. I do this stuff all the time, right? So for me, it's whatever. This is like my run of the mill,
Right.
you know, way. This is the way I make my living, right? But thank you for answering the questions, and thank you for being here today.
Thank you,
Thank you,
Representative.
Mr. Chair.
Further questions or comments? Representative Doucette.
Sorry for the second time, Mr. Chair.
Oh, sure.
You know, as I'm listening here, and I asked the question earlier, because again, I profess my ignorance of many areas of this, of criminal law. But as I was asking earlier, you said it was a ticket, something like a ticket. And I've heard we fleshed out a little bit more about what it was. But I just, you know, in looking at the applicable statute relating to disorderly conduct, it is in fact a crime, in this case, a misdemeanor, 53A 182. So you do admit today that you were charged with a crime and that there were criminal charges pending against you, correct?
Not is that correct? We were never charged. We were cited with a summons, and those charges were not moved forward. We were never charged with a crime.
Okay, but there were charges that were registered on the docket system under 53A 182 disorderly conduct that were pending for a period of time until they were resolved in the manner that you described that they were resolved.
I don't know if they were, I mean, there must have been, because we were issued a summons. So we were summoned to court under that, I assume.
They must have been. They must have been.
They had to be on the docket
Right?
somewhere.
Of course.
But
I guess I'm a little concerned why that is so difficult to discern, and why you coming here today wouldn't have been better prepared for that question and been able to tell us definitively that this is what happened. But we've spent some time talking about what was a ticket. Well, what was the ticket? It was a summons. I guess it was what, you know, I guess I'm a little more concerned now that you wouldn't have taken the time to prepare your answer to that and really understand the charges that were pending, what they were, and technically. And again, you're not a criminal lawyer. I'm not a criminal lawyer, but you went through this experience, so I would have thought that you would have been better prepared to explain to us exactly what it was. My second question is, you raised it again. When you are coaching, volunteering, and you get a background check questionnaire that has asked you if you have ever been charged with a crime, has that ever been a question on a questionnaire that you've had to answer, and how did you answer it?
I answered honestly, I have not. We have not been charged. And if the representative thinks I'm being vague, I'm not trying to be vague, and I'm trying to be definitive. The DA or the state attorney charges people with crimes. This police summons you to come to court for an arraignment. So I think it's called, it's an arraignment, saying, okay, we're going to charge you with this. How do you plead? That didn't happen because it was short circuited. So we got the summons, show up at court, informal conversation, and that's as far as it got with the classes and whatnot.
Okay.
So, yeah.
Okay. Thank you, Mr. Chair.
Thank you. Representative Gilchrist.
Thank you, Mr. Chair. Sorry I can't be there in person. Thank you, Mr. Shaban, for being here. If this were any other type of hearing, I wouldn't give credence to an anonymous testimony, but because this is such an important role and we didn't receive too much testimony, we did receive testimony in opposition to you, and I'm hoping you could shed some light. Why would someone question your relationship with neighbors who may be LGBTQ?
I have no idea. I have no idea on any of those things. Why would anyone, having not seen it, I should probably look at it, but no, there would be no credible question or challenge or position that would relate to that front. If there is something that was put in there, maybe it's an old political rival. I have no idea, but that is not the case. That is not who I am, nor has it ever been.
Okay. Thank you. Thank you, Mr. Chair.
I want to, Attorney Shaban, I just want to maybe give you a little bit of a chance sort of on this.
Mhm.
I think the questions about this arrest, folks are kind of digging down on the domestic violence issue, and I think probably trying to understand
Mhm.
how seriously, part of what folks are trying to understand is how seriously you take that issue or don't.
That's fair.
As somebody who had an opportunity to serve with you on this committee, um, I want to acknowledge, I'm aware of at least one vote you took on this committee that I think was somewhat unpopular, maybe with some members of your caucus, that I think shed some light on kind of how you view issues of domestic violence. And I'm referring specifically to then Governor Malloy's bill to take away firearms from on a temporary basis, the so-called TRO bill, to take away
Right, I do
firearms
remember
from
that, yeah.
those who were charged with domestic violence offenses. And I went back and I was looking up the vote rolls, and I do think you were one of the few Republicans to vote in support of that bill.
I did, yeah.
So I did think it was important to sort of acknowledge that, put that on the record, and say that. And I don't know whether you want to sort of comment kind of on how, maybe just more generally, your thoughts on the nature of domestic violence crimes in our state.
Yeah, thank you for bringing that up, Representative. And yeah, I did vote yes on that because there's a lot of varying viewpoints about this right, that right, but the first responsibility and obligation of law enforcement, and then in the context of that, this committee is safety. So when in doubt, do what's right to keep people safe. And not everyone agrees with that. Not all of my colleagues supported my vote on that and on some other bills related to similar issues. But that's fine. I voted my conscience, and the policy days are behind me. But that domestic, and this goes back to Senator Flexer's question about our smaller police departments in the 3 towns that I used to represent and I still live in. That's most of their calls, other than traffic stops and whatnot. That's unfortunately, the lion's share of their work. And it's unfortunate, but we have to enable our law enforcement officials and the courts and everybody else to be cognizant that sometimes people have to be separated, or sometimes people have to reconsider their behavior, or there's just and we have to be aware of what's real, what's not. But when in doubt, keep people safe.
The other thing I wanted to give you an opportunity to talk about, because I don't know that we've really dug into it, is your legal background,
right,
and what you've done in private practice and why you believe that's a resume that we should consider for the bench.
Just well, I mean, you guys, you all have resume and the information. I mean, I graduated in 1993, Pace University. I was cum laude. I also got an environmental law degree. It was a separate degree, so I got 2 degrees that day. And I started working for a very large firm based in New York. It was the Connecticut office, Kelly, Dry and Warren. They had offices all around the world, doing mostly commercial litigation. I mean, as a first-year associate, all of the serving lawyers here now, I was also running and getting coffee and making copies, for that first year. But it was big stake, high commercial litigation. Very interesting stuff. Very interesting stuff. That firm had just come off of the Bhopal litigation from India, a few years before. I started doing securities litigation, some insider trading cases as a junior lawyer on some bigger cases. We had trials down in New York City. We had some 10b-5 cases, litigation cases, and then the run-of-the-mill contract stuff, employment stuff, and whatnot. So that was like the first 3.5 years of my career. That I switched to Whitman, Breed, Abbott and Morgan, which was the amalgamated firm from Breed, Abbott and Morgan and Whitman and Ransom, with 2 firms have been around since 1800 something. And I started working in Midtown Manhattan. I commuted in every day. Again, mostly commercial
litigation. We get a lot of intellectual property work. Went all around the country. I had a couple of cases in California that took me out there. It was interesting cases. It was sports memorabilia and the rights to use the indicia of famous athletes and whatnot. But it was real money at stake. We also worked with the U.S. attorneys on that case to stop the sale of fraudulent sports memorabilia across state lines. So that was fun. Worked with the U.S. attorney out of Chicago. I left that firm after another 3.5 years to rejoin some of my Kelly Dry colleagues in a smaller office in Westport, which was sort of an offshoot from Cummings and Lockwood. Same stuff, a lot of commercial litigation, some landlord tenant work, mostly business side, intellectual property, a lot of court work. Both of those in all the three cases, we're also doing some pro bono work, some blocking and tackling wherever we could. And then finally, I went back to Whitman, Breed, Abbott, and Morgan, which was had sort of coalesced in Greenwich, and was there for 17 years as a partner. During which time I also became a member of the General Assembly. But again, whether it was environmental law, white collar crime to some degree, commercial litigation to a vast degree, a lot of contract litigation, a lot of business litigation, and it's odd because for the folks who've been practicing a long time, when your first 10, 15 years, you work to litigate and win the litigation. And the next 10 or 15 years, you try and work to keep your clients out of court because that's actually the way to go. If you have to litigate, you do. You position pieces on the board in such a way that if you have to litigate, you're in a position to win. But you try and navigate both the litigation system and then just the commercial constructs so people can resolve their differences whenever possible, right? We're companies big and small. With that, I think I mentioned before, I was a fact finder arbitrator for a bunch of years before I got elected. So I presided over small claims cases and some similar cases. Once I was elected, you couldn't hold, even though you could still work as a lawyer, you couldn't be in both branches of the government. So I had to withdraw as a fact finder. I was here for 6 years, withdrew, ran for a different office, didn't win, and went back to private practice. And I'm pleased to have been appointed as a Superior Court magistrate last year. We're doing, again, small claims, some docket clearing, there's some traffic citation work we're going to do. I also just got hired a few months back by Post University to teach legal studies. That just started to figure out how that might or might not work. I was proud to do that. And then, in terms of legal practice, that's sort of the pile. It's 30 years in and out of court, and mostly New York and Connecticut first, New York second, and then some other states.
Thank you. Senator Winfield.
Thank you, Mr. Chair. I want to turn first to question number 8. About if you're appointed to serve, are you willing to serve anywhere in the state?
Yes.
I don't think I've seen someone qualify that answer before. So that's interesting to me. Do you want to talk about that? Because you did say yes, but then you went on to say, well, I live here and it would be easier to serve in these areas. I don't think I've ever seen that before.
Oh, well, I didn't mean a qualified senator. What I was hoping to do is to give the committee information to say I'm positioned to serve almost anywhere, just where I live. That was the intent of that. It's like you could say yes, and I did, but I also say, and I'm perfectly positioned to serve just about anywhere. Just to sort of reinforce the yes. So I'll go where needed.
So I'm going to read your answer in that case, because I don't know how I'm supposed to, and I didn't think this was going to expand into anything more than just checking, but I don't know how I'm supposed to read. Yes, I note that I live in Reading, so Danbury, Stamford, and or Bridgeport would be an easy commute. That doesn't suggest to me anywhere.
Well, I could tell you what, I could also serve easily in Waterbury and or Milford.
Yeah, sure, add that in.
And
none of that suggests to me anywhere.
Well, I think I named 7 of the or 8 of the judicial districts saying, if I'm needed in New London, I'm getting in the car going to London. The idea there was to actually add some context to say it was a genuine yes, that I can serve easily in all of these places, and I'm happy to do it. And if I got to drive to New London, off I go.
Yeah, I guess I guess it just goes to the point I made earlier. The way that I'm receiving some of your answers, I don't think is the way that either you mean it or the way that you understand what you're sending. Um, Senator Flexer asked you a question, but she qualified it in a way by asking, had you had other involvement with police? And then she qualified it by talking about that you got a different type of treatment based on the fact that you were who you were. I'm just going to ask, have you had other involvement with police?
Like personally getting in trouble kind of stuff. I mean, obviously, but you know, my kids got in some trouble. My dog got loose a lot. So there was a lot of that. And
I'm gonna
maybe occasional traffic ticket.
I'm just gonna say to you, I hate in some ways the way this process will work, where there are rumors and innuendo. But sometimes what happens after this is that some things that are rumors become hardened, right? And so I want to just give you an opportunity, because there have been suggestions that there have been other things. I'm just going to be straightforward with you. And so I just want to give you an opportunity, if you know of anything, to say yes now, so that we don't find out later and then that's a problem. But you aren't aware of anything else
other than what I mentioned. Stuff with my kids, my dog getting loose. I did call 911 once because I had to go to the hospital. I got a hernia had come undone. So, you know, I think that showed up on a 911. You know, was that a police call? No, I called 911 and they sent the cops in the ambulance, which was nice.
Yeah.
That's it.
Okay. And I take you at your word, unless something, of course, would suggest differently.
I appreciate it.
You know, and then just some commentary. You and I served on this committee together. We served during a time that Senator Kissel and I were joking a little while ago that I was in some ways known to kill off nominees. Was part of my history. And so, you know, you were here to observe both what things are problematic. You were here to observe how this process works. So it does strike me as a little strange the way that you have performed today. Because if anyone should be coming in here prepared for what happens here, it seems like it should be you. And your answers to me have felt either unprepared, or I don't want to say you're obfuscating, because they just have not felt as complete and direct as they should be. And I will let you know, and I think you'll understand this, that sitting here, you have what's right in front of you, and you also have the feeling that you get. And I have tried to stick to what I have in terms of information, but there have been times when that gut check thing that I've ignored has not served me well, where I've been on this committee long enough that, boy, I should have paid attention to my gut, right? And so that is a concern of mine. I will tell you, as I sit here today, thinking about what I do when we get to a vote on you, and I think it's only fair to let you know that. I also think about the fact that you're not just an attorney who's been serving in whatever capacity you've been serving on, but you've, again, been on this committee. You've watched how these things have unfolded. And let me say, like Representative Staffstrom, you voted, from my perspective, right on other bills as well, including the body-worn camera bill at one point. So this is not about where you stand politically, but it's just, I don't have the greatest feeling for someone who comes in front of us, is aware of how the process works, and then when we ask them about what happened in their own case, they seem kind of unaware of what went on. The other thing I'll say is this. I think your comments were about the perspective shift, the ability to recognize things you hadn't recognized, were meant to suggest something about you that, strangely enough, doesn't make me feel great. Because as I sat on this committee with you and others, one of the things that I, at least at that time, was repeatedly saying was that folks aren't paying attention to the perspective of other people. And they're talking about what happens in their community despite people coming to share their experiences. And I guess I guess as someone who sat here, and we had much longer hearings at that point, I think you'll remember.
Yes, we did.
And watched all those people come and talk about their experience with the system. I guess I have some level of concern about your ability to really take in what's in front of you. If it took your own personal experience to be able to recognize that, yeah, the system doesn't actually work for everybody all the time. Yeah, people who don't have the privileges that you and I and others have experience a different system. So I don't have more than I just want you to know, and I haven't determined what I'm doing, but I want you to know that there are, from my perspective, some real concerns with the way that you've acquitted yourself here today. And congratulations on your nomination.
Well, thank you, Senator Whitfield, and I enjoyed serving with you. I truly did. So,
Further questions or comments, Representative Fishman? Oh, Representative Tigliano for the first time. You're on mute, Representative.
Thank you, Mr. Chairman. I appreciate the recognition. I listen a lot. I'm new to the committee and I'm not a lawyer, so I don't always chime in or have the proper question to ask somebody. But I did listen to Attorney Shaban's testimony today, and I have to tell you, I had a different perspective. I found it very human. I think some of these experiences in his life make him a better, well-rounded person. I thought his answers were pretty good, considering that we all go through things in life and it makes us better, we improve, or a different person. I think if something ever happened in my life, I would like to sit in front of somebody like Attorney Shaban, who's sort of had those life experiences, that maybe understands what we're going through and would have a different, more compassionate perspective. So I just wanted to say that when I heard some of the terms of concern for some of his answers, I actually found some of his answers very human and inspiring, to be perfectly honest. So thank you, Mr. Chairman.
Further questions of the nominee? We're obviously going to have a chance to debate this later as well. So further questions of the nominee, Representative Fishman?
Thank you, Mr. Chairman. Attorney Shaban, I asked you early on about the New York situation. And do you recall the case of Genworth versus Shaban Edwards?
yes, I'm involved. Yeah, that just finished.
Yeah, and that's one of the cases you filed something during that period of suspension. Is that fair?
That's a good question. I don't remember when that case was filed. It must be.
I can tell you that the
Yeah,
case
you
was
have it in front of
originally filed April 10 of 2023. So that would have been.
That would have been that, yes.
Yeah.
That would have just been inside that. yes.
And at that time, you filed an appearance on behalf of Shaban, and in fact, you represented to the court that your address of the law firm was in New York.
Well, I have two. Yeah, we have a New York office and a Connecticut office.
Okay, but that's what you represented during your period of suspension.
Right.
From practicing in New York.
That's the Western District of New York, the federal court.
It's in New York, right?
Yeah, I'm just
The
saying.
state in
that's
which you
federal
had been
court, yes.
suspended from practicing law. Okay, I just wanted. Still trying to figure out the legalities here, and I really got it. This criminal case. You know, we've heard about AR. Nobody's mentioned the family violence education program here today, right? AR you have to apply for.
Right.
There's a fee. And I've heard representations that you went through the AR program. Well, that was actually what was said. Did you actually go before a judge on the day that you got to court for the arrest?
No.
Okay.
I went to the state's attorney.
Okay. And I'm going to tell you, everybody who watches Law and Order knows that you were charged. Okay. You just can't get around that. You were charged with a crime. The summons results from that. The police officer determines at the scene whether or not there's probable cause to charge someone. They give you a PTA, promise to appear. You've been charged with a crime. 9 ways to Sunday. Okay. The adjudication of that thereafter is something totally different. So the program, I've heard a program. Okay, now family violence education program is a very familiar program to me in the domestic violence cases that I've handled. Did you actually apply for a program through the court process?
No, they said there was not an application for AR. We did not do an application for.
something totally
Okay, then the only thing I did is I contacted ARC and saying I'm required to take 3 or 4 hours. And I've been told that this is acceptable. How do I get on the schedule?
Okay, and I mean, because there's different ways this cases go. So an AR is a program, and usually somebody reports to court like a year later, there was compliance and the case was dismissed. Okay, that's my experience with AR. Okay. Sometimes there's although rare, show proof of some sort of therapeutic intervention and we'll enter a nollie. Do you have any idea what happened here?
It's as Senator Kissel helped me describe. It was we met with the state's attorney early, beforehand, said pursue this course. When you do, let me know and we'll drop everything.
Okay, I'm not aware of any court in this state and that is dismissing domestic violence cases under those confines. Okay, I will tell you that in my experience, most courts, in my experience, are entering a nollie, which is totally different.
Right.
And I still don't have an answer here.
Well, this wasn't a domestic violence case.
It certainly wasn't. It certainly wasn't. It certainly wasn't under our statute.
All right. Hold up 1 second. Hold up. All right. I know the day's getting a little long, and I know it's Thursday. It's been a long week for everybody here with JF. You remember JF week
Yes,
and
I heard
Judiciary
your
and my
deadline
committees
just came,
and
yeah.
everything else. So, but we do have to keep a transcript. So I want to make sure we're not talking to each other. Representative Fishbein, ask a question and then we'll get an answer, please.
As a result of the police being involved in your case, was a criminal protective order issued?
No.
Okay, so there was nothing precluding you from being around your girlfriend, nor your girlfriend being around you.
That's correct.
I'm going to tell you that's a rare occasion. So did you tell the police officers at the scene that you were a former state representative?
No.
Did they know that?
I don't know if they did or not, but it's a small town. So, if you know the police know you, they know your kids, they know, what you do. So it's possible they know. I'm not sure.
Okay, well, thank you, Mr. Chairman.
Further questions or comments? If not, Attorney Shaban, thanks for being before us today.
Thank you, everybody.
Rosemary Weber. Could raise your right hand for me. Do you swear or affirm as the case may be the information provided this committee be the truth, the whole truth, and nothing but the truth to help you God or under penalty of perjury?
I do.
Great. Have a seat, and then whenever you're ready.
Good afternoon, honorable members of the Judiciary Committee, Chairs Staffstrom and Winfield, Vice Chairs Flexer, Gadkar Wilcox, and Fazzino, Ranking Members Kissel and Fishbein. I am Rosemary Weber, and it is an honor to appear before you. I want to thank Governor Lamont for nominating me and General Counsel Natalie Braswell and her team for their guidance throughout this process. Finally, I'd like to thank this committee for your service and consideration today. By way of background, I am a first-generation Italian-American whose parents set a firm expectation of working hard
and helping others. That began with helping in a small stone church constructed by the Italian immigrants from my community. When I was tall enough to see over the podium at church, I became a lector. And until I left for college, I was the lector at Sunday Mass. This planted the idea in that my voice could be a powerful tool in service to others. My opportunities for service expanded during college. I applied to serve my country in the Army ROTC program at Penn. It was Army ROTC that trained me how to use my voice to lead others and support a mission. And upon graduation, I was commissioned a second lieutenant and placed on active duty. I served on active duty at the National Training Center at Fort Irwin, California, and I was selected to be a company commander. As a young female officer, I quickly realized that my voice would not be enough to lead a company of soldiers. My experience taught me that soldiers will do what you tell them to do because of the rank on your lapel, but they will not trust you until you prove yourself. I learned that leaders serve others, sacrifice, and render thoughtful decisions grounded in sound judgment. After spending 3 years on active duty, I completed the remainder of my service in the Army Reserves to pursue my dream of becoming a lawyer. Over the last 26 years, I have had the privilege of using my legal training and my voice to help resolve a variety of matters both in private practice and state service, having spent the bulk of those years representing parents, children, and the Department of Children and Families in abuse and neglect cases throughout the state. I have handled over 170 contested matters and more than a dozen appeals at the appellate and Supreme Courts over the last 10 years alone. In my current role, I lead a section that represents 4 agencies: DMV, DOT, DAS, and DOH, in various and at times complex litigation. My duties are primarily supervisory in nature, and I take great pride in being a part of the professional growth and development of the talented lawyers in our section. None of this would be possible, of course, without the love and support of my parents, my husband, who is also a veteran, and our 3 children who inspire and encourage me every day. All of this is to say that the opportunities that I've had in and out of the courtroom have prepared me to take on the awesome responsibility of a Superior Court judge. I pledge my deep commitment to the rule of law and steadfast service to the people of Connecticut. I thank you for your time, and I welcome any questions.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Well, Attorney Weber, who would have thought many years ago when we were going door to door that this is where we would end up? And you are just an outstanding applicant and candidate. And I'm so happy Governor Lamont saw fit to nominate you and that you're here before us this afternoon. Not only are you a veteran, and thank you for your service to our nation, your husband is a veteran, and not only a veteran, but a veterinarian that is highly respected in our neck of the woods. But also, you also served various capacities in Granby in local elected office. So your whole life has been one of giving, giving, and giving. And I think that this is the natural culmination of your years of active service. And your legal background is incredibly impressive. And I'm actually very happy that Attorney General Tong is willing to give you up, and that he didn't write and say, "Don't give up, Attorney Weber," that you're here before us. So I had a small part in moving your name forward. I'm happy I was able to do a little bit, but it was just bringing a wonderful candidate before the eyes and ears of the people that make the ultimate decision. And I think the people of Connecticut will be extremely well served by your kind heart, your concern, not only for families and children, but for the betterment of Connecticut. And I can just congratulate you and thank again Governor Lamont for nominating you.
Thank you for your kind words, Senator Kissel.
Further questions or comments, Representative Osborne?
Thank you, Mr. Chair, and good afternoon, Attorney Weber. It's great to see you here. You and I began my litigation career on the juvenile court panel with you in New Britain more years ago than I want to admit right now. But you bring to the table a really unique package, is that, as I said, you and I started out on the same panel representing children and parents in abuse and neglect cases.
Right.
And you jumped ship and you went to the other side and you represented DCF, and you almost never see that happening. So you bring this really unique perspective. And one of the things that we sometimes have a danger of is, once you have a hammer, everything looks like a nail, right? But you've had both hammers. You've had both sides of that experience. So how do you think that breadth of experience in representing different sides in the exact same kinds of cases for so many years, how do you think that will inform your approach to cases?
So I think it will help because I won't necessarily have a feeling one way or the other that there is a right answer. I think, especially in child protection law, I think we have the opportunity to collaborate and be creative in terms of how we resolve cases. I think that it is really important in those cases to make sure that you understand the background and the context of the people that are coming before the court. There are times when families have needs, various service needs, whether it's mental health services or substance abuse, addiction services, and the ability to navigate that with the ultimate goal of hopefully reuniting children if it can be done so in a safe way. I think that the court has a very important role in doing that. And that, I think, is what I will continue to do, to look at all sides and make sure that nothing is being done in a heavy-handed way, that all voices are being heard, and that people are being treated with dignity and respect.
Well, I'm just so delighted to see your application, and thank you and good luck.
Thank you.
Through you, Mr. Chair.
Rep. Fishman.
Thank you, Mr. Chairman. Good afternoon. You've been here all day and I appreciate that. Back there beaming, just so that you have a bright smile and it's very welcoming. I want to thank you for your backup. Unfortunately, some people can follow directions, some people can't follow directions. One of the things we asked for is, why was the case significant to you? And you very succinctly gave us, and I love reading these because I actually learn nuggets of law. I didn't know about that case, so it's very interesting to me as a law nerd. So I just want to say I very much appreciate you following the directions because others didn't. And congratulations on your nomination. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? If not, I just want to say, I don't know that I've ever seen where it says list over the last 10 years, how many cases have you tried? And you put down 172 in a 10-year time frame. I gotta imagine those aren't 10-day trials each. No.
No. So in child protection court, any one case could have at least 3 trials. If it comes in, and Representative Osborne knows, on an order of temporary custody, if it's contested, that's a trial. There can also be a trial on an underlying neglect petition. That's a second trial. And then if you get to the point of a petition for termination of parental rights being filed, that's a third trial. In between there are other contested matters, such as permanency plans that have to be filed with the court on an annual basis. Those can also be contested trials. So I think you heard earlier, the pace of child protection is fast and furious. And unfortunately, there are a lot of cases to manage. And that's how you rack up 172 trials.
172 trials over a 10-year period.
Yeah.
Gosh, God bless you. All right. Thanks for being with us. Congratulations on your nomination.
Thank you.
Justine Whalen. You could raise your right hand. Do you swear or affirm as the case may be that the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of
I do.
perjury? Great. Have a seat, and whenever we're ready, we'll take your opening statement.
Good afternoon, Chairman Winfield, Chairman Staffstrom, Vice Chairs Flexer, Gadkar Wilcox, and Fazino, Ranking Members Kissel and Fishbein, and other distinguished committee members. Thank you for the opportunity to appear before you today. It is a true honor. I want to thank Governor Lamont for his confidence that he has shown through my nomination and to his staff for their support throughout this process. My name is Justine Whalen. I was born and raised just outside of Boston, mainly by my mother. Though she was single, she was not alone. Support came from family and friends, all of whom truly influenced who I am today and instilled the importance of education, hard work, and treating others with respect. I am grateful to so many people for allowing this day to happen. I would not be here without them. Following law school and a judicial clerkship with the Massachusetts Appeals Court, I began my career in public service as a public defender. First in Massachusetts and now in my adopted home state of Connecticut. Serving in this role in our justice system and providing dedicated representation to individuals oftentimes overlooked or cast aside has been a humbling and rewarding path. Over the past 15 years, I have represented thousands of indigent clients and appeared in court on a near daily basis, handling criminal cases at every severity level. My significant litigation and trial experience has strengthened my ability to think quickly and remain steady under pressure, often when the stakes are very high for those I am representing. This work has enhanced my skills as a trial lawyer, but has also made me a more understanding person. I have learned the importance of listening carefully, keeping an open mind, and remaining patient through difficult situations. I have overcome countless challenges by working hard, seeking guidance from colleagues and mentors, and maintaining a commitment to continual self-reflection and improvement. I have tried to practice law in a very simple way. Be prepared, listen, and treat everyone, clients, lawyers, judges, and staff, with dignity and respect. If deemed fit by this committee and given the great honor of serving as a judge of the Superior Court, I will strive to perform my judicial duties in the same manner. I will be prepared to utilize the knowledge I possess or to learn any aspect of the law with which I am unfamiliar. I will listen to parties with patience and impartiality, and I will continue to treat everyone, regardless of position, with civility and respect. I believe my experience has prepared me for the great responsibility of serving Connecticut's citizens as a judge, and I respectfully request your approval. Thank you, and I am happy to answer any questions you may have.
Thank you. Questions to the committee, Rep. Fishbein.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
I apologize. I didn't create the agenda. You're the last one on the list.
Someone has to be last.
I guess. So I apologize for you having to sit through all this today. I just, when I was starting to go through the backup, I was like, Commonwealth. Connecticut's not a Commonwealth. Where does this come from? And I figured it out, So I was like, is she even licensed to practice in Connecticut? And I got to the thing. So can you just explain the transition? Because you've got lots of experience. That's the one thing I didn't get from the paperwork.
Yes, of course. So in 2019, we had our first child, me and my husband. We were living in Boston. That's where I was born and raised, as I said in my opening statement. And we wanted to move to a suburb. We were in Boston in city life. He grew up in Branford, was born and raised, and began taking me to Branford, I want to say in 2007, and I fell in love with the shoreline. I did go to the University of Connecticut. I do have family who grew up in Connecticut, and I have a history here. I do have roots here, but that really in 2017 is what has sort of started really building the roots that I had in Connecticut. And when we decided to move our family out of the city, there was no other place that we could think of. We wanted to be here. We wanted to be in Connecticut. I applied to the public defender's office many times because I wasn't willing to give up that aspect of my career and my dedication to public service. And eventually they did let me in, and I went there in 2019. I was able to work with the GA 23 in New Haven for a little over 2 years. And then I was hired by the New Haven JD, where I've been since 2021.
Well, that's great. Just, I hang out at Hotchkiss Grove in the summer. So I'm in.
Wonderful place.
I'm in Bradford a lot. And also, looking at what's been, you get here 2019 and 2020, we have the pandemic. So
Yes.
that must have been a culture shock, and you survived it, and here you are.
Survived and thrived. I believe that it was Attorney McGinness and I were speaking earlier about, we were actually selecting a jury when the world sort of came crashing down. And the way that we knew that this was happening was one of the potential jurors was a public health employee. And he came in a full on, it wasn't even an N95 at that point. And all of the lawyers, the judges, the staff, everyone looked at each other and realized something is wrong. And we immediately disbarred the entire process and went home for the next period of time. But it was an interesting time. It was something that I was very grateful to have the people that I was working with. I think one of the things that I am very proud of is how quickly I developed really strong working relationships, not only with the people in the public defender's office in New Haven, but also others in the courthouse. I was pregnant at the time, and everybody was so supportive of each other, of me, of everything during that very difficult time.
Well, congratulations on your
Thank you.
nomination. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, congratulations on the
Thank you.
nomination. Thanks for being with us. All right, so that is going to conclude our nominees. We do have one member of the public who had signed up to testify. Madam Administrator, is that person with us? They are not. So at this point, I guess I'm going to declare our public hearing closed. I'm going to convene our committee meeting for April 2nd. We are going to break for caucus. We potentially could still vote this afternoon, although I'm going to preface now, it is not a certainty, and I would say probably unlikely that we get back from caucus in time to vote. I know we have religious holidays tonight. Some of us got to get back to Bridgeport to get our feet washed in time, and among others who have Passover festivities tonight. So we are going to break for caucus, and then we will update folks on whether we're actually going to vote or whether we're going to recess the committee meeting tonight. All right. Caucuses are where, Madam Administrator?
Republicans are in room 2D and Democrats are in two B.
Okay, and there'll be a little bit of a break between now and caucus. All right, thanks, everybody. We stand in recess. All right, I'd like to call back to order the Judiciary Committee meeting for April 2nd, 2026. The time is now 4:04. And as I said before, I know obviously we have religious holidays, both Jewish and Christian faiths tonight. So given that members are still in caucus and given the hour, we are not going to be voting on the nominations today. We're not going to vote on any of the nominations tonight. What we're going to do is recess the meeting today. We will plan, I believe the House and the Senate are both going to be sending referred bills to this committee likely early next week, which we'll need to set an agenda to take that up. So our plan right now is to reconvene on April 10th, Friday, April 10th, at which time we would take up the referred bills from the House and the Senate floor that'll come to us Monday and Tuesday, as well as the nominations that are still with the committee. All right, Madam Administrator? All right, so with that, I will adjourn our committee meeting for today, and we will renotice a meeting for April 10th. All right, thanks, everybody.